Adjournment.
Adjourn.
Understood?
Yes.
My lord, kindly pass over this.
Item 3.
Please, your lordship.
Yes.
In previous date of hearing, the learned state council is directed to obtain the up-to-date status of the case.
Yes, Mr.
My lord,
Goda, you
in
have
fact, I contacted the IO, my lord,
Yes.
though he has not sent the instruction, but in fact, talked with him, one witness only examined in time, and also he is
Lordship,
highly
one
one PW has already-
PW,
One.
he is a victim and husband of the
What do you
informant.
want? What do you want?
I want the deposition slip is also available with me, sir. Lordship.
But in this petition, what do you want? Trial is on.
Trial is
One
one,
PW is direct.
but one date of occurrence is in question. As per the information of the informant, it is clearly stated in your FIR. The date of incident took place on 22 of February 2021. But as per the deposition slip,
You are challenging cognizance order.
I am also challenging
Charge has
the.
been framed. Prosecution evidence started going on. PW1 has already been examined. Why should I interfere in this matter?
Lordship, the date of cognizance is also is question. The informant clearly stated that the 26th, there is not occurrence took place on 26th.
cognizance part
The
already.
trial court will look into it. If
That benefit they
if
will get.
witness has said anything in your favor, you will be acquitted.
Acquitted.
Not that the cognizance order will be. See, right now. In this petition, the petitioner has challenged the order dated 14/3/2022 passed by learned C. P. Kujang. Kujang in GR case number 211 of 2021, whereby the learned court below has taken cognizance of the offence against the petitioner. The notice was issued to the opposite party. Notice was issued to the opposite party. Mr. Ragada IPS for the state and informs the court that after in the present case, charge has already been framed and the prosecution evidence has already started. One witness has already been examined. In view of the aforementioned development in the present case, no interference is called.
Lordship, my humble submission before your lordship.
Yes.
After the एक वर्ष ହେଇଗଲା କୌଣସି evidence ହଉ ନାହିଁ. Lordship, expedient trial.
And
With
at this stage, the land council for the petition submits that since last 1 year, there is no progress in the trial. Hence, he seeks a direction for expeditious disposal of the case. Free, fair, and speedy trial is a constitutional right of an accused. So, therefore, in any case, the petitioner is entitled for a speedy trial. In view of therefore, I expect that the trial court will do well to see that the trial is concluded as expeditiously as possible. Yes.
Item 4.
Yes.
May I please? Your Lordship? As per your lordship's direction, I have filed the charge sheet copy and the entire order sheet also.
Yes. What do you want?
My lord, the order of cognizance under challenge, my lord, kindly have a glance to annexure 2, my lord.
Charge has been framed?
No, my lord, the commitment hai nahi.
Yes. Why should I interfere?
My lord, the annexure 2, kindly have a glance to annexure 2, my lord.
Yes.
After lodging the affair, the victim herself swear an affidavit before the lower court, my lord, before the court of first instance. The para 3, that due to some misunderstanding between the deponent and the accused persons, the case has been lodged.
Bring her.
Bring her.
Bring her. Yes.
Yes, my lord. But the problem is that she married elsewhere. For that reason, I employed her party by addressing to daughter of.
If you want that I should interfere and quash it on the ground of settlement, she should be here.
Yes, my lord.
I'll issue-
Yes, my lord. Issue.
I'll issue.
Your-
Issue notice to opposite party number 2. Mr. Ragada appears for the state and waives notice. Let counsel for the petitioner has taken me to the affidavit filed by the opposite party number 2 before the court below, wherein she has stated that due to misunderstanding between the deponent and the accused person, the case was registered. Then counsel for the petitioner further submits that there is a settlement between the parties, and he seeks adjournment to enable him, enable the petitioner to appear before this court.
Opposite party number 6.
Petitioner also,
My-
petitioner as well as the opposite party number 2. Returnable date in the meantime, the proceeding before the court, which court, where is that application? Proceeding before,
The learned SDJM Hindol.
in the application, you don't write anything.
Yes, yes, my lord. That is there, my lord.
Where is that? Further proceeding in GR case number 452 of 2021, pending in the court of SDJM
Hindol.
Indore, state till next database. Yes,
Obliged.
yes.
5,
Here, my lord, I have challenged the proceeding as well as the order of refusal to discharge me. That is the order. The offences, my lord, charge sheet was submitted under the UAP Act and section
Charge
1.
has been framed.
My lord, yes, charge has not been framed. At the stage of framing of charge, this is filed, my lord.
Formal charge is not framed.
That is, we have not done. Though, we instructed the IO regarding status of the. No, charge has not been, not categorical mention. Charge has not been, no. And this is-
Instruction to whether,
Yes.
taking cognizance of the
Yes,
court
yes,
below,
because attending the.
sanction obtained.
Sanction,
Yes,
that
yes.
has not come, but another date. For date. And in meantime, Lord, today is date fixed for framing of charge. I pay for stay of further proceeding. Because on the face of it, it's not maintainable. You have no jurisdiction, the additional.
The matter was taken up for hearing on 13/2/2024, and the court has passed the following order. Right down. Following order. Mr. Ragada appears for the state and seeks further time. Then counsel for the petitioner submits that the matter is fixed before the court below today.
Yes.
Today. He further submits that he would be moving appropriate application to the court below for seeking adjournment, owing to the fact that the matter is sub judice before this court. He may do so, and it is expected that the trial court will accommodate the petitioner till the present matter is disposed of. Yes. Next.
item 6,
Please, your lordship.
Yeah.
I am filing citations.
What is this matter?
Yes,
Cognizance.
quashing of a criminal proceeding as well as cognizance on the ground of the another coacted person has been acquitted on contest.
You must be absconding.
Yes, yes.
Yes.
What to do?
But there is a several decisions.
There is
Well-
several decisions, but you have to see. Show me the acquittal order. Show me the acquittal order.
Yes,
First of all,
That is on technical ground or on merits.
not on merits.
placitum of
on-
the case, you lordship may just
Kind of.
out of 7 accused persons, only
One
one accused acquitted, other 6 accused are absconder. In the meantime, I have taken instruction. 5 persons have been taken into custody, and they are in custody. Perhaps I don't know.
You
whether
are
they
also in custody.
And now,
No.
this man
You
is
are
absconding.
Yes.
This man is absconding and immediately has been
Absconding.
issued.
Can you see
And it's a case of 116
They have
kg,
not-
50.
in the
Gram
judgment,
ganja.
in the judgment, there are only relevant witnesses is 11
When
and
the incident has taken place in 2013
13.
and you have been absconding and the acquittal order is 2018.
Yes.
Today, after 2018 also you have absconded. Show me the acquittal order. Where is
acquittal order.
If there is no evidence at all,
No evidence.
then in that case there is no point.
This is the
and-
assessment. The underlined court made an assessment taking into consideration the evidence adduced by the prosecution. After all, at the end, he found that there are some contradiction, and that is why that accused is
No, he has not,
acquitted.
he has not.
Not that
rightly.
not that the
What are the
prosecution has been
offences?
turned hostile.
What are the offenses? by
Offense 20B of NDPS.
NDPS.
Yes, NDPS.
And the
Where is the NBW order?
NBW order under annexure 3, running page 38.
I will say it and go and appear.
Yes.
Yes, ma'am.
I'll quash it.
My
I'll
lord,
quash the NBW order. You go and appear before court and move appropriate application.
Yes.
That's the best way.
kindly see the
You get
judgment.
50% relief. What do you want? Write down. The petitioner has filed this petition under 482 CRPC seeking quashing of the entire prosecution against him on the ground that one of the co-accused person who faced the trial has been acquitted by the court of additional sessions judge cum special judge Hon'Ble, Hon'Ble full stop. By the order dated 26 to 2018, the learned special judge Hon'Ble by in special case number 67 of 2013 had recorded acquittal in favor of one of the co-accused person, Jagabandhu Sahu. Mr. Maharaja appealed for the state, submits that there are as many as how many accused?
7 accused persons.
7 accused persons, out of whom only one accused was put to trial as he was apprehended. The other accused persons have been absconding.
Absent.
Of late, 5 accused persons are apprehended and they are facing the trial. Insofar as the present petitioner is concerned, still he is absconding. Therefore, the court of the special judge Hon'Ble, while its order dated
22/9/2014
had issued the NBW against him.
Right.
NBW against him. Learned counsel for the petitioner states that his client would appear on instruction. He says that his client would appear on before the court. He surrendered before the jurisdictional court on or before 30th of March and seek remedy available to him on the basis of the aforementioned submission and facts of the present case. The order dated 22/9/2014 is set aside, subject to the condition that the petitioner shall appear before the jurisdictional court on or before 30th of March 2024. Disposed of.
The judgment may be kind taken a note of at the time of.
And he may seek appropriate remedy before the court below. On the strength of the judgment that he is citing before this court. So all the judgments there.
7.
Yes.
My lord, this case has been filed
Yes.
as the affair was registered after 22 months. Because this case is about a WhatsApp messages which was received by the petitioner. She is a class 1 officer and she had other problems because of accident and all harassment was there. So this was an important part where she had to get certain information, but the police had not registered and she had done right from 2019 to till it was got registered on 21/1/2021.
What are the offenses?
My lord, offenses is it is 354D, then 509, read with 67, section 67 of IT Amendment Act.
What is she is what is this? She is retired.
Right now retirement. While she was working at Bhubaneswar, she is right now at.
What are the allegations against you? Let us see that.
My lord,
What are the allegations?
allegations, sir, the unknown person has sent WhatsApp messages continuously about 45, which was informed to the police. She had gone to the DCP also, opposite number 3, and ran till opposite number 5, the IIC Chandrasekharpur. But nothing has happened. After 22 months, they have registered me. Then after.
What are the offenses? That's what I'm asking. What are the offenses?
I'm saying, my lord, they are.
354D, 354D, 509/34 IBC. The petitioner is the informant.
Informant, yes.
And he has filed this application in action of the police. And this, when there is no other provision, then only 482 is there to.
Yeah, why you
in
have
action
to
of
file
police
a
is the other
petition? What can I
application.
do? I
This is
can't
not the-
control their investigation and all.
This is
File a
not the-
My lord, they have not
226.
even done any investigation on
That's right,
That's
226,
yes,
not 482.
not 482.
Go and file for it to, if you are the informant and some messages have come. What are the messages? It is so explicit.
Yes, my lord.
The
It's about
representation, representation.
it's messages, songs, voice messages, which is obscene, which cannot be seen. A lady, there's an insult to the lady. And it's
The person who has sent the WhatsApp is your friend.
sorry, my lord.
Your friend. Your friend.
No. He's unknown.
Unknown.
This is the problem, my lord. This harassment is
Well,
was
have you
there.
registered a case?
Yes.
It has been registered, my lord.
Investigation is on what to do.
No investigation has been done. Repeatedly, she has represented also.
Should we file an appropriate application? This
Have you gone to the police?
Or my lord, that's the point.
I just, Mr. Maharaj,
my lord, my lord.
I'll just record his statement and dispose it up, look into it. Why
Yes, yes.
unnecessary harassing her to again go to?
That's all.
Okay.
Santosh.
The petitioner is the informant in which case?
That is
Informant in
Bhubaneswar Chandrasekharpur PS case number 60 of 2021.
Chandrasekhar PS case number 60 of 2021.
21. Yes.
Her grievance is, despite the fact that the FIR was registered on 28/1/2021
Yes.
under section 354D 509 and 509 IPC, read with section 67 of Information Technology Act. No action has been taken by the police as yet. He has placed on record many representation. He has submitted before the police, but the police appears to have not given any hit to any of his representation. Therefore, he seeks indulgence of this court. Mr. Maharaja, appearing for the state, submits that he will inform the police to take appropriate action on the representation given by the petitioner on the basis of the aforementioned statement of State Council. The present petition is disposed of. If any other grievance is still left to be addressed, the petitioner has liberty to approach appropriate format at appropriate stage. Disposed.
A free copy of this.
Free copy. Yes.
May
May I please, your lordship?
Yes.
This is a case, lordship, quashing the criminal case number. It is pending for FDM Sadar, your lordship.
Speak little louder.
With,
Proceeding.
yes, your lordship. Yes, lordship. That has been mutually, that has been done, your lordship. Page 16, your lordship.
You have settled the dispute.
Yes, yes, already been settled, your lordship.
Okay.
Lordship, kindly see page 16.
Page
Page 16, lordship.
16,
16, sir.
What is this?
This is both the petitioner number 1 and as well as the OP number 2, your lordship. That is the wife, your lordship.
13B application has been.
13B application.
Yes, lordship.
At the instance of the opposite party number 1, opposite party
Two.
number 2, FIR FIR number so and so came to be registered against this petitioner. Petitioner is petitioner number 1 is
Yes, sir.
former husband of opposite
number
party number 2, whereas petitioner number 2 and 3 are the in-laws. Letter counsel for the petitioner submits that the parties have settled their dispute and decided to part ways. Accordingly, they moved an application under 13B of Hindu Marriage Act, seeking divorce on dissolution of marriage by mutual consent. The learned court, which court? The family court.
No, sir, already been decided, your lordship.
Family court Cuttack,
Yes,
by
sir.
its order dated
22/6/2021.
22/6/2021.
Yes, sir.
Has allowed the prayer for dissolution of marriage. Hence, he seeks indulgence of this court for quashing the proceeding. Issue notice to the opposite party number 2. Mr. Maharaja accept notice for the state. State next pick up. In the meantime, the proceeding before the so and so is state.
Oblige, lordship.
Yes. Keep the date.
Item 9.
Yes.
May I please, your lordship? Yeah. multiple proceedings are there between husband and wife. Starting from 498, DB proceeding, maintenance proceeding by the wife.
Always your husband or
Husband. Divorce proceeding are the instance of husband. से कौन करचंदी नोटिस इश्यू कले लीगल नोटिस मु सर्विसिंग पाई जाइतली मोर माइलेज कंप्लेन थिला सेटा डिफेक्ट रिमूव हेलानी दैट लीगल नोटिस देले हमकु तारा
who are these people? 7 people.
all the employees of the employees and directors of the company.
What is the allegation against?
allegation केवल मोर डेफिशिएंसी इन सर्विस जदी वाला कंपनी रो जदी डेफिशिएंसी इन सर्विस शी शुड हैव
Why have you not implemented the informant?
आगे इन्फॉर्मेंट को करछ ना इन्फॉर्मेंट को पाकी
Where is it? Implement informant.
sorry I just I
Not just do it and come. You need intervention of this court. You don't implement the proper party. I would have. We should notice. Do it and come. Next week, let
To-
consider the petitioner seeks time to
Can I-
implement the informant. These are minimum thing at your stage.
डे आफ्टर टुमारो तुम आज कर दे
At your experience, साला ये
ना ना इट्स माय मिस्टेक माने आई बोला डे आफ्टर टुमारो आसु आज कर दे इन कोर्स ऑफ डे कर दो डे
next week may not be possible. I'll give you the date. Implement. We'll see. Okay. Next.
Item 11.
Yes.
To the complainant petitioner, my lords, the accused persons have been cheating, and lastly on 34, 2023, they threatened and not to return the money, neither to sell the piece of
What
land.
was the reasoning? For
Reasoning, my lord, sole reason is that the subject matter is in civil nature.
Naturally, you are
Ne-
trying
my
to
lord-
recover arm twisting method.
My lords,
Arm twisting method. You want recovery of your money. You
No,
also
no.
registered a case.
my lords, only I have allegation.
Do you have an agreement or any contract with him, the accused?
Yes, my lord.
Then seek enforcement of that.
No, my lords, yeah, honorable apex court, I am,
Show me the facts first, then you go to apex court. Show me the facts whether case is made out or not.
yes, my lords, case is made out. Criminal ingredients are there, my lords. I have given the entire statements of the five.
How much you have paid to 2 lakh, 2 lakhs? What is it? 45 lakh.
No, no, my lords, 15 lakhs, thereafter 2.5 lakhs.
When have you paid? When have you paid?
My lords, in the year 2020.
20.
20.
Which year, which month?
My lords, that is in the month of August.
August. Still limitation is there. Still limitation is there. Don't fight. Initiate some civil proceeding. Otherwise, we will lose.
No, my lords,
Both the
3 years civil proceeding,
August 2020, huh?
my lords.
20.
5/8, 2020.
Then limitation gone.
No, my lords, they
You can't ask
have,
for recovery also. You can't ask for.
no, recovery, my lords, only the criminal elements they are there.
Chalo, I'll issue notice because you have lost the limitation. We'll try to recover your money.
My lords,
That's the only thing we can do it.
my lords.
Otherwise, you should have filed a civil suit. Why are you banking up in this? This is arm twisting method. You to extract money, your own money, of course. But if the criminal case is not made out, you should have initiated civil.
No,
proceeding
my
also,
lords,
apart
the
from this.
learned SDGM held that relying a decision of this honorable court.
Anyway, I'll issue notice to opposite party. Where is the opposite party? Who is opposite party?
My lords, 1 to 4.
I'll issue notice. Let us see if they can give you some money.
My lord,
Okay. Issue notice to the opposite party number
1 to 4.
1 to 4. Retainable within 2 weeks. Let them come with.
My lords,
Remind me that time so that we will see.
my lord,
We will send to mediation or something.
my lords, my
Right. You should get back your money.
my lords.
Okay. Yes.
Item 13.
One NBW issue.
Senior counsel is waiting.
My lords, I may take the notice.
Yes,
for
yes.
Speed post.
Speed post. Speed post. Senior counsel is waiting in. Yes, ask. Is there the other side is there?
Item 49 is motion to police. 49.
Private complaint.
Right.
Okay. You do it. Yes. मला item 13. Yes. मला NBW issue
When?
the year of
When
2020.
you got bail, when you got bail?
Belgium, my lord.
Belgium.
When you got the bail? Do you have an idea?
My lord, Belgium.
You will jump the bail if there is a bail. Tell me the bail.
No one.
Then
21
bail
7
jump, bail
2000.
jump. What is bail? When you got the bail?
My lord, petitioner NBW warrant against my
I
petitioner.
know that NVW is issued on
21/7/22, ma'am.
when you were on bail or not. You are saying bail jump. That means you were on bail. Tell
Yes,
me the date.
My lord.
26/9/2013, my lord.
13
26.
session court granted bail.
9/2013 bail 500 was. Yes.
Item 14.
Thank you.
Yes. Yes.
Item 14.
The same. This is
Same, my lord.
when you was
My lord.
bail. Do you have any idea when you was on bail? He was on bail. Though. He was on bail and could not appear in the court on 31/8/2023. NBW issued was 500.
Yes, my lord.
Yes. Next.
Item 15.
Yes.
Hello, afternoon, section, my lord.
Yes.
22C, a complaint of NDPS Act, my lord.
50 kg, 500 grams, my lord. CD is required. CD and CA, my lord. More than commercial content. 50 kg, 500 grams.
What is conscious position
My lord.
or
No, conscious.
Played away.
No, my lord, the prisoner is the owner of the vehicle, my lord.
owner of the
He
vehicle?
played away leaving the vehicle, my lord. Subsequently apprehended.
Get CD.
My lord, CD, CA, my lord.
CD.
Antecedent.
Okay. Let the CD come. Madam. If there is no conscious position, 37 doesn't
No conscious
come in
person,
here.
my lord.
We'll see. Okay. CD. So, give it. Huh? Yes.
Item 16.
May I please the Lord?
Yes.
My lord, on behalf of Mr. Kuldeep Mahante, I may be permitted to withdraw this case.
Withdraw. Yes.
Item 17.
Grateful, my lord.
Yes.
My lord. Officers of 420, 468, 471, my lord.
Hmm?
471 RTC, my lord. My lord,
Sorry. What?
I think you can 420,
420?
468, 471, ITC, my lord.
Okay.
My lord,
You are in custody since?
I am custody since, my lord.
Hmm.
20/12/2023, my lord. 20th December 2023, my lord.
Yes. Come to the rejection order.
My lord.
What does it?
Answer to page 13, my lord. Allegation is that, my lord. Business taken money of 8 lakhs, my lord, on the premise to give this informal job, my lord.
This petitioner have taken 6 lakhs rupees in order to provide them service, my lord.
6 lakhs rupees you have taken. You are working in the district legal
Exactly.
services authority. In the court premises, you started doing all this.
My lord, the
And online 5 lakhs,
job, my lord.
87,000.
Have you returned the money?
Exactly.
Will you return the money? I'll grant you bail. Return the money. You are doing all this thing in the court premises. You are working in the court.
My lord,
And why
there was
lenient?
agreement between the petitioner and to refund the money, my lord.
You refund, you have taken money 6 lakh rupees.
Online 5,87,000 and 13.
5,87,000 online you have taken.
Online.
Actually, money was taken by somebody else, my lord.
This is the allegation. Will you pay? I'll let you out.
Some amount I will pay, my
How much?
lord, 1 lakh.
50% 60%.
50% at least you do.
But 2 lakhs.
Why are you
Someone
you have
else-
taken online? The money has come to your account, 5,87,000.
That was taken
The
by
poor-
someone else, my lord.
The poor girl seeking job
That was
And he
taken by
might have
someone else, my lord.
might have arranged the money by
Exactly.
selling this thing. No. You pay. Right down.
It's only enjoyable job they let it, but they are not satisfied with their job, my lord.
You have asked, you told that in district legal services authority, I'll give you a job. And take the money and giving the job somewhere else. Okay.
But
Right.
2 lakhs.
Right on. The petitioner is in custody since 48
Whatever they teach, my lord.
The allegation against the petitioner is that he has taken about 6 lakh rupees from the informant, out of which 5,87,000 he has taken online through online mode. RTGS, you've taken RTGS
Online mode.
Phone
through
pay.
online mode. That is what
My
is
lord,
written.
my lord.
Online mode.
Online.
And 13,000 he has taken in
In
cash
cash.
from the informant with a promise to arrange a job to her in the district legal services authority in Sambal.
No, the department of telecom.
As a data entry
Data entry job.
operator
In the
in the
department of telecom
recycling
department.
project, in the recycling project, etc. Okay. And after taking the money, the petitioner has avoided to respond to the informant. Therefore, she has filed this. She has filed the complaint on the basis of which the FIR was registered. Then counsel for the petitioner submits on instruction that he would be depositing 3 lakh rupees before this court. 3 lakh rupees before the court below. Subject to complying the undertaking given by the counsel for the petitioner by depositing 3 lakh rupees before the court below. The petitioner is released on bail, on the conditions to be imposed by the cases court.
Well, he also cooperated the investigation.
My lord.
Investigation is still on.
My lord. Petitioner submitted.
Since investigation is still on, the petitioner is further directed to cooperate with the investigation.
But 2 lakhs. Knowledge of the Togoto Malad.
Bail order pattern there.
It should be reasonable also.
Right.
Give 3 lakh, no problem. Don't move application for modification, I tell you. I have record your consent. I am not giving direct. You have said, go. Dispose.
18. May I please your lordship? Offense under section 21 of the NDPS Act, my lord. Petition is custody 15/9/2023, my lord. 15/9/2023. In custody.
23.
157 grams of brown sugar. Heroin.
Brown sugar.
My lord. That my lord, antecedent my lord, call for
My lord, call for city antecedent.
Brown sugar most.
No, kichi nahi.
Brown sugar, no brown sugar in Orissa, at least. Spare Orissa.
My lord, call for city.
Ganja, till ganja, it's tolerable. See, this is the manners you should not be.
They don't see.
Will you withdraw or dismiss?
My lord, call for city. First time.
I will not give bail. What is the use of it? Even if I call for CD, I will not. In the brown sugar, I will not.
My lord, call withdraw, permitted to withdraw with liberty. Yes. After.
The counsel for the petitioner seeks to withdraw the present petition to repeat his prayer, to reiterate his prayer at the appropriate stage with this liberty the petitioner is.
But also 20 also said. Yeah, set a 10 gram.
Brown sugar को छाड़ दो किसी दिन रहूं and it is only 2-3 months only. 2-3 months. Brown sugar. Let us not encourage brown sugar. Yes.
20 ଟା
नहीं 19 sir.
20 करिए.
20 ଟା 10 ग्राम में
अच्छा
10 ग्राम नो एंटीजन
10 gram. I am calling for the CD. 20 CD call for them. 20 I'll just 10 gram. Okay.
My lord, on behalf of Mr.
What is the age of this boy?
मेरा 20 रे
The age of this accused.
37 my lord
37 years. Okay. Call for CD in so far as 20 is concerned. 19 days. Okay. Yes, 21.
19.
My lord, on behalf of Mr. Kuldeep Mathi, may I be permitted to withdraw this case?
Withdraw. Very good. Withdraw.
Thanks.
Huh? Memo bail application.
So better.
So and so APS on behalf of. What is the name of? What is your name, ma'am?
Pragya Tripathi.
Pragya Tripathi APS on behalf of Kuldeep Mahanti. Under the counsel for the petition seeks to withdraw the petition.
Memo, they have already filed memo.
Memo is there.
Memo I will file. That has not come. The court master will come. Slip is there.
21 Miller, 10 kg of ganja Miller. Recovered 10 kg. Only
10
20 be 2 b.
But subject to verification of criminal understanding. That's why
Yes,
directly
yes.
releasing bail, subject to lower court to verify criminal understanding.
Similar type of criminal understanding.
Similar type.
Code कौन थी?
Bail granted. The subject to the verification of antecedent of the petitioner, the trial court.
Similar type.
Similar type. The trial court shall impose appropriate condition.
Only 10 kg you lots there.
10 kg.
Below comment sir.
Yes. 22. Yes.
We have had is under section 457, 350, 435, 294, 506.
Yes.
And if your lordship will read the FIR itself, then
You are in the custody since?
since the 1st January, 2nd January.
Yes, Mr. Raghunath, what is this? These offences are not serious.
Judgment, I have judgment.
What is the allegation?
What judgment is?
Allegations is that in the courtroom, their fire was.
Not the, this time already, I want to malad.
But if your
But they have
lordship is.
entered inside the courtroom and set fire records.
Okay. CD called. CD called. Let us see.
Court will proceed court
Then if your lordship will see the fire itself,
even
a
setting
person
will be
from two-storied building.
Whatever in the court premises, you started doing all this.
No,
things.
no.
They can have some records.
I am calling for the CD. Let us see.
ଏଥିରେ ମାନେ FIR story ଟା ବି ଆପଣ ପଢିଦେବେ ଯଦି ଦେଖିବେ
You are entitled for bail, but let us see the CD. But because all these things has happened in the court premises, that's the allegation. Therefore, we have to be.
the allegation is court premises, but if you
Inside the courtroom, my lord. And
how he entered, that is the question.
Smoke is coming out from the window of the courtroom, and he found the main door of the courtroom was locked from inside.
How?
All these things. In the court premises you have done, so therefore
No.
we'll have to see. Okay, CD. Yes. Next.
23. 23.
Pass away.
24.
376(3) is there, my lord. See, notice is to go, my lord.
Notice.
Yes, my lord.
Notice. CD. Court.
If I my lord is unknown affair, offense registered 395 my lord, allegation 58,000 took away from the liquor shop my lord. But during investigation, some of them arrested and on basis of the co-accused statement, this petitioner was implicated my lord. The petitioner is not knowledge about the pending of the case is 2015 case my lord. While my lord all of a sudden
You are
on
in custody since?
26/12 my lord 23.
all of them granted bail by this court as well as anticipatory bail as well as by the lower court.
Case of 397, my lord, 395 and 397. So I don't have CD and the other bail application is pending.
Not this petition.
Says that.
Anticipatory bail by even some persons.
490.
What is the allegation against him?
Allegation is 4 unknown persons came in the liquor shop and took away the 58,000 rupees and all accessories in night hour. That is from the salesman, my lord.
By assaulting the.
That is the allegation. It is a 2015 unknown affair, my lord. And
That is why 397 is.
the implication is
Grant bail what? Granted. Bail granted. Chalo, please.
26.
And don't go to the liquor shop today.
no, my lord. No, my lord. Never, my lord.
After bail, you have to go there only.
No, my lord. I am a contractor, my lord. No.
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 To celebrate or otherwise also you can go there only.
No, my lord.
Yes.
26.
26. Bathroom.
27.
Passover.
Your Lordship, item 27, I seek for a passover, Your Lordship.
28.
Why?
Yes, since last 2 years, since the principal accused stated that the present petitioner.
You are not apprehended from the spot and all.
No. Basing of the statement, I am in custody.
ଆପଣ question କହିଲେ କଣ ବୁଝିଲେ ଆପଣ ସେ ସ୍ପଟ ରୁ ଆରେଷ୍ଟ ହେଇଥିଲେ
No.
ସେଇଟା କହୁନା
No.
କହୁଛି ଆଜ୍ଞା ବେଲ ଆଲାଉ କରନ୍ତୁ
Allow.
କୁଆଡେ ଯାଉଛ
28. Whatever is there against first filter, everything will.
ସେ କିଛି ବୁଝି
My lord, I may be permitted to mention, my lord, yesterday your lordship has directed to me obtain the report regarding the date of the victim.
This matter you are talking about?
Yeah, my lord.
28.
That has been fixed for 29/2/2024, my lord, passing. And with the 164 statement, my lord.
I just forgot. What is this case is about?
The case is registered charge sheeted under section 376(2)(n) and 66(c) and 67 of the IT Act, my lord, with the other offences, my lord.
After the victim is going to examine, my lord, deposit statement, my lord, before the court.
Acha.
Day after
Let the victim be examined.
Yesterday your lordship has asked my lord and friend my lord to against.
Yes. Let the victim be examined.
Yes, on 29 to
Give a date after 29 days. We'll examine. Let the victim be examined.
Yes, my lord.
After the victim is examined, we will simply examine. The matter is fixed on 28th of 29th of March. According to evidence up to the victim before the court below. Then
29th of February, my lord. Your lordship, can you keep it on the 8th of
We'll see. Next.
29.
My lord, the petition is in custody since 19/7/2023 under section 19/7/2023.
Okay.
My lord, under section 498A 306/34 of IPC, read with
Your husband?
Husband, my lord. My lord, the
One minute. 30?
498A 306/34 of
Investigation is still on.
My lord, charge sheet has been submitted and now the matter has been already been committed to the court of session. And
charge is under 304B.
No, my lord.
306 only.
498A 306/34 of IPC. Read with the 4 DPR.
all allegation suicidal because of
Okay, husband. Grant. Bail granted. Bail granted.
Item 30.
My lord, now the matter has been committed to the court of session and number million.
memo likhi
Memo, give the memo.
Okay.
Court master immediately.
My lord. Okay.
So this all conditions will be imposed by the court.
Victim statement, promise to me.
ଏଗୁଡା କରିବ କଣ?
What is it?
Yes.
Item 30.
May I please, my lord?
Yes.
My lord, this is a case under section 417 and 376. The promise to marriage and kept physical relationship. Already charge sheet has already been filed on
What are
25/12.
the provisions? What are the provisions?
Well,
FIR?
417 and 376,
Promise to marry.
my lord. And the victim is 20 years. And
Boy is 20. The
victim is
the woman is 30 years, and he forcibly committed rape. That is the rejection.
Was this FIR against 3 unknown persons who are trafficking some minors to the Andhra Pradesh in order to engage them in farming purpose.
374.
374, madam. And so far the present petition is concerned, he was not
370 and 374.
74.
Okay.
And here, so far the allegations against the present petition is concerned, he was not arrested from this spot. After 3 weeks, on the basis of the confessional statement of those 3 persons who were arrested at the Damanjadi railway station, and all the boys were recovered.
My lord, not only the confessional statement of court, my lord,
allegations
also there are the victim and the guardianship of victim's statement as there. This person particularly, main person who has been arranged the minor girls and
What are the allegations? Ajab, item CD has not come, huh?
no, my lord.
So adjourn it. Awaiting CD. Huh? Date sort. We'll give the date. Sort it, try. Huh? Yes. 33. NDPS?
No.
No. His case 31.
After
31 NDPS.
76 elopement case.
Why CD is required? POXO is there. POXO is here. Yes. Next 33.
But alleged offense is under section 450, 342, 395.
Allegation, tell me the allegation.
Allegation, my lord, that some unknown person, 6 persons came wearing helmet and committed Dakati. Alleged that from one person's 5,000 rupees and from another person's wallet 42,000 rupees they took away.
Dakati of 48,000.
48, my lord.
Yes.
48 and another from another person 5,000.
1 point.
And one.
Using
Alleged. All 4 persons wearing helmet and another 2 persons wearing mask. They are waiting outside. 2 persons.
You are wearing helmet or mask?
No. I was not my FIR was registered against unknown person. This present petitioner.
If you put the helmet and all, how would
No, that is not the case. Thereafter, the petitioner was apprehended in another case. He was arrested in another case. 3-4 cases, my lord, I have been remanded. In this case also, I was remanded.
4 numbers criminal antecedent is there, my lord.
That I am submitting. I was remanded in this case along with another 2 cases. Altogether 3 cases I was remanded. Originally, I was arrested in another PS case number of, my lord, PS case number.
In this case, you tell me what are the evidences.
There is an allegation against me that in that case I made confession that I have also committed this offense. That is why I am remanded in this case.
Oh, you are banking up on his confession.
Yes, my lord. My lord, he has remanded from another case and confessed is guilty, my lord. And the weapon has been seized, a country pistol.
That case.
Weapon is seized in that case, not in this.
No. That is only confession in that case. Nothing has been seized in this case. They may only on the basis of the confession in that case, they remanded me in this case and also another case.
But my lord,
1 minute.
may I permit to read just 2 to 3 line, my lord, confessional statement.
Yes.
My lord, ମୁଁ ସାଇଲି ଅମୁକ ଯୋତନା ଗଲା ଏଇକି ଯେ ଆଜି ତା 12:23 ତାରିଖରେ ସନ୍ଧ୍ୟା ପ୍ରାୟ 6 ଘଟିକା ସମୟରେ ମୁଁ ମୋର 2 ସହଯୋଗୀ ବବଲୀ ସିଂ ଖୁଣ୍ଟିଆ ଓ ଅନିଲ संगरे गोटे मोटरसाइकिल 4 नंबर 100 आसी सीधा ग्रामर SBI ग्राहक सेवा केंद्र
This confession statement is recorded by the police.
Yes, ma'am.
Has he signed it?
No, my lord.
You will use the confessional statement of accused in some other case, and without any evidence in this case, how will you keep him?
Admitted, my lord, that I was.
What confession? What kind of confession?
I mean, in custody while remanded in this case since 29 September 2020.
Do you have any other material except confession?
This much, my lord.
You filed the charge sheet and all.
Submitted charge sheet because already more than 5
filed the charge sheet. What are the material you have collected? Any recovery, anything beyond the confessional statement?
My lord.
Then How will you sustain it?
Charge sheet as regarding the charge sheet, my lord.
अरे 29
charge sheet.
11 12 13 4 मास 5 मास आला.
You were apprehended in which case?
I was apprehended in paragraph 12. It is written internal page of the impugned order Mallet 2. I was apprehended.
1 minute, 1 minute.
In Joda PS case number 243 of 2023.
Para?
Internal page 12 of the impugned rejection copy, running page 12.
Yes.
First
paragraph.
Yes.
The Telangana Council of Petition submits that the accused person was arrested in connection with so and was remanded to the state.
And remanded in this case.
Yes. There go. The petitioner was arrested in another case in connection with was arrested in connection with the Joda PS case number 243 of 2023 under section 394 397 IPC reduced 2527 Arms Act corresponding to GR case number 656 of 2023. When he was in custody, it is alleged that she has confessed that he is also involved in the present case. On the basis of the confessional statement recorded by the police in the present case, he was remanded. He was remanded. The petitioner is custody 29/9/2020.
There is no instruction.
Charge sheet has been submitted. My instruction is
But
submitted.
there is no instruction regarding charge sheet. Copy nahi mo pakde. Yes, admitted, but copy is not with me.
Admitted, not admitted.
Not.
He is submitting charge sheet has been filed.
You should tell
Document is not there.
That
So you have to supply the copy of the
you
charge
are
sheet.
the
so that
supporter.
Telangana Council of Petition submits that the charge sheet has been submitted. However, Mr. Rao, appearing for the state, submits that the charge sheet has not yet been submitted. This is the matter on suggestion of J to obtain instructions regarding the status of the investigation.
Yes.
Please.
Whenever there are more than 2 to 3 criminal incidents, their cases might not be directly admitted petitioner to file a comprehensive affidavit, but which case?
Meanwhile,
that is one of
the petitioner also
comprehensive affidavit.
to file comprehensive affidavit regarding the antecedent of the petition.
Antecedent.
But in this case, irrespective of antecedent, see, if you don't have anything except the confessional statement, why is not entitled for case? Give a short date. Only I want to know whether charge sheet is filed.
Yes.
If the charge sheet is filed,
Yes.
show me any other evidence apart from the confessional statement.
Yes.
There
Yes.
or
Yes.
if it is there, let us see the veracity of that.
I submitted because I am in custody for about 5 months. Because within 4 months I have to submit charge.
Whatever next week I am giving,
I will lordship.
file under the rule it is required that you have to file the affidavit saying what are the antecedent you have.
Rule.
Practice.
Regular practice.
Not true.
That's it. My friend is very that otherwise I would have been granted bail there because within 120 days, if charge sheet would not be filed,
that is
I would have been granted. So I've been custody. I've been custody remanded since more than 5
I am
months.
going to give you bail. You.
That's my friend is objecting.
And let us see whether
Regarding
charge sheet is filed or not.
Filed. That
Yes.
is.
Offences are serious, but there is no material.
No
Therefore,
material.
you have to go.
Yes, sir.
That's all. Let them come forward. Yes. Next. Yes, I'll just.
It's a little.
phone करते charge sheet টা sanction
30,
34.
34.
May I please, your lordship, my lord?
Yes. 376 2L.
Yes, my lord.
Yes.
And in this case, my lord, the informant victim has been directed to appear, and she has already appeared before the court and filed a affidavit before the court, my lord.
Affidavit before this court?
Yes,
Yes,
my
my
lord.
Was there any order to that effect?
Yes, sir. Earlier order was to file an affidavit.
Copy of affidavit has not been filed.
And it is the case that they are in
What does she say in the affidavit?
they were in living relationship, and there was a trouble between them, and that's why this affair. And
Now what? You started staying together?
she wants that he should be released, otherwise she is suffering because there is nobody to support her and a child.
That only the informant from name. Persons to the order dated which order? Where was the order there?
8/2/24 ହେଇଥିବ ବୋଧେ.
8/2/24.
24.
That order is not there in the record. Where is that?
8 ना 9 रहते.
Yes, there. ये पीछे लगा देते हैं. This matter was taken for hearing on 8/2/2024. The following order was passed. Pursuant to the aforementioned order, the victim girl has filed an affidavit dated 9/2/2024.
Woman, my lord.
Victim.
Woman.
He adult to me.
My lord.
Filed the affidavit dated 9/2/2004. Inter alia stating that the accused
In Badambari PS case.
Inter alia stating that she was in a live-in relationship with the accused since last 1 year, and at her instance the FIR was lost. She doesn't want that her partner to languish in jail further, and she is facing the problem in maintaining herself. Therefore, she prays that the petitioner should be enlarged on bail. Taking into the consideration the fact that the victim has considered that she was in living relationship with the petitioner, and when you are in custody
Since 1st of November, my lord. 1st of November 2023.
1st November 23.
Yes, my lord.
In custody in 1st November 2023. No, bail granted. Yes.
Obliged, my lord.
36.
Yes.
May I plead your lordship? The petitioner is in custody since 19 January 2024, your lordship.
What is the offense?
Taking bribe for the allegation under section 7 of PC Act.
7 PC Act.
Yes, your lordship.
What were you doing?
Pardon, your lordship. I am a headmaster, your lordship.
And you are collecting money for whom?
From the contractor who was assigned with the work for renovation, your lordship. While disbursing the bill, it is allegation that out of 22 lakhs 53,000 and something odd, already 18 lakhs something it disbursed. For the rest amount, he demanded 50,000. And he will.
You are the police constable.
I'm the headmaster.
Headmaster.
Yes, your
You are
lordship.
headmaster. Construction of the school.
School renovation.
Renovation.
Renovation. And already in custody since 19/1/2024.
Yes.
More than.
Yeah, 20th January 2024. 20th January 2024.
The case was registered on 19th and same day trap was made and I've been remanded to custody, your lordship.
Allegation of 50,000.
50,000.
Where is that?
That is.
ମୋ ପାଇଁ ମତେ 50,000 ଟଙ୍କା ଲାଞ୍ଚ ଦେବି କହି ମତେ ଏ ଟଙ୍କା ଦେଇ Where is the FIR?
The formal affair is at running page 8, Your Lordship.
Running page 8, huh?
8.
Yes, that's what I'm reading. What is the allegation?
The last, this page 9, Your Lordship.
Page 9.
Yes,
4th line.
4th line, yes.
ମତେ 50,000 ଟଙ୍କା ଲାଞ୍ଚ ଦାବି କଲେ ମୁଁ ଏତେ ଟଙ୍କା ଦେଇ ପାରିବିନି କହି ସେଠାରୁ ଫେରି
You are the
ଆସିଲି।
contractor.
Yes, Your Lordship.
The informant, the informant was the informant.
I may submit one line only as per the instructions received. Besides this trap case, one inquiry is going on against this petitioner regarding possession of disproportionate assets. So he should cooperate in the inquiry. That's my prayer before your
inquiry, Your Lordship. They will.
My prayer before your Lordship, he should cooperate in the inquiry.
Petitioner is facing the investigation is over. Charge sheet is filed.
No.
The investigation is going on.
The petitioner is in custody since 19/1/2024 in the FIR number so under section so. The allegation against the petitioner is that he has demanded 50,000 rupees from the contractor who has been engaged for constructing the school.
The renovation work for
the school building. The state council appearing for the state submits that he is also facing, the petitioner is also facing the investigation in a disproportionate asset case.
Inquiry, he said.
Inquiry in a disproportionate asset case. And he submits that the petitioner should cooperate with the inquiry officer or
inquiring officer.
Inquiry officer in that case. In that case, grant bail with the conditions. Yeah.
37.
May I please, Your Lordship? Yes. Initially, case answer 328, 354B, 354C, 506,
320. Where is that?
328, Your Lordship.
328.
And subsequently, it has turned to 376 is added. And Your Lordship, in annex
76
is added. And annexure 2.
Who are you?
I'm in custody, Your Lordship.
Petitioner.
Petitioner.
Clearly, you are in the custody, therefore you are in the court.
Lordship.
Maheshwata Maharana.
Maheshwata Maharana is the informant.
My lord. I am appearing on behalf of the informant, my lord.
Yes. What do you say?
They were having love relation between them.
Annexure 2, let's say.
You are in custody since
24/12/2023.
24/12/23.
Last occasion, Your Lordship directed to call from the IO about her.
To taking the instruction regarding the genuineness of this affidavit, my lord, but the instruction has not come, my lord.
The informant had filed an affidavit also, my lord.
Informatics. The informant is also present, Your Lordship.
You settled. The matter was taken up for hearing by the coordinate bench on 13/2/2024, and the following order was passed. Persons to the said order, Mr. So APS for informant, and submits that indeed the petitioner was in a love relationship with the informant to the party number 2. The petitioner is in custody since 24/12/2023. Taking into consideration the aforementioned facts and duration of the custody, the petition is granted bail. Yes, granted bail.
Informant is also present, my lord, here.
This is by bail only. I can't quash. File a quashing petition. I'll quash it. Shall I record it?
No.
Will you?
Sorry, my lord.
Shall I record that you will be filing a petition under 482 for quashing? What do you say?
Yes, Your Lordship. Yes.
But he says no.
Lordship, because they are going to marriage, Your Lordship. So
the council's appearing for the parties submits that they, in view of the fact that the parties have settled their dispute, they would be filing a petition under section 482 CRPC for quashing of the FIR. FIR. Record करके तब pay it. You file it. Okay.
My lord.
I have granted you bail. File 482 petition. Bring it to I'll quash it. Okay.
May I please your lordship? This is under section 20B, 2B of NDPS Act. Quantity 5 kg, 200 grams of ganja, my lord.
5 kilo.
5 kg, 200 grams.
5 kg, 200 grams.
You were. It is recovered from you.
My lord?
Recovered from you.
Yes, my lord, the police is saying that.
The police only will say, or we will tell her what. Okay, 5 kilo, na?
Yes, my lord. Of course, my lord, below commercial content, my lord. But, my lord, 2 criminal antecedent is there, same nature of allegation, my lord, offense.
Don't bring that, let him go out.
Yes,
5.3.
5 kg, 200 grams.
5 kilo, 200 grams. Below commercial quantity, granted bail.
My lord.
Yes.
39.
May I please your lordship?
Yes.
Here, my lord, petition has been implicated in the 7 of PC Act, my lord. Here,
7?
Yes, ma'am. Petition is the principal of the college, my lord. And in
Principal of the college.
Women, my lord.
Custody since?
Custody from 28/2024, my lord.
1/24.
Having also no criminal antecedent, my lord. And here is the case, my lord. Allegation is that my lord, husband of the informant was working as an assistant librarian on the college, my lord. And allegation is that to clear up the enhanced arrear bill from 2018 to 2022, he asked for gratification, and while giving 50,000 at her residence.
You are working as what?
Principal of the college.
Principal of the college.
Yes, my lord.
Principal of one school. Informants.
Is a direct
Principal of higher secondary school.
Principal of higher secondary.
Yes, ma'am.
For the Kerango.
And the informant's husband is working.
Assistant librarian on the said school.
The petitioner, the allegation against the petitioner is that he has demanded rupees 50,000.
Yes,
from
ma'am.
the husband of the informant.
Yes, ma'am.
Informant. For clearing?
For clearing the arrear enhanced bill from 2018 to 2022.
20. Full stop. On the basis of the said allegation, the FIR number so and so dated 18/1/2024 as registered under section 7 of PCA. The petitioner is in custody from 20th
January
2010. Taking into consideration the custody period and all, granted.
May I pray the same order? Inquiry is going on.
I'll go
same order.
For DA case, one inquiry is going on.
State submit that
Paragraph 4.
Inquiry pending.
Paragraph 4 may kindly be perused.
Inquiry pending regarding the disproportionate asset case against the petitioner. Therefore, when it comes for the opposite party submits that the petitioner should cooperate with the inquiry, pending inquiry in regard to DA case. With this condition, grant bail. Yes.
Item 40.
May I please,
May I please, your lordship?
Yes, sir.
Your lordship, the 311 petition has been rejected by the London trial court.
Yes.
Yes, your lordship. Under section 311 petition has been rejected by the trial court. The present petitioner is challenging the present petitioner is an informant, your lordship. On last occasion, your lordship, directed to the state council will file the for response of that, your lordship. But may I permit your lordship kindly place one judgment of Honorable Supreme Court.
What is the case? Judgment later on. Let us understand what is the
Case is that your lordship.
The informant filed the case for recall of Pedol 3. Pedol 3 is the wife of the informant, madam. In the lower court, trial court, the prosecution filed the APP filed the petition 311 to recall. That has been rejected.
That has been rejected.
The government is not come here.
He is the informant.
Yes.
He says allow. Why are you?
No, because of your lordship on last occasion.
The informant has also.
Prosecution moved an application under 311
Yes.
for recalling of which witness?
PW3.
PW3, which was rejected.
PW3, the wife of the
The
informant.
wife of the-
Informant came here and filed the petition and recalled it. You are also allowed that. But in fact, in the paragraph 5, that has some my lord missed.
Paragraph 5 of?
My lord, the fact order, my lord. CRLC, they ordered 3/1/2024. Instead of my lord, the prosecution that mentioned as a accused petitioner to re-examine. Prosecution re-examine. That is
PW3, na?
my lord.
Yes.
That much, my lord. Prosecution to examine.
Write down, write down.
That will be modified, my lord.
Petitioner is the informant in the present case.
Will also be in the that has been recalled. Will also be an adult. Earlier order was recalled, madam.
The prosecution moved an application under 311 CRPC to recall PW3.
Yes.
Shwetapadma Naik.
Yes.
Isn't it?
Yes, yes.
Shwetapadma, right.
Who is the wife of the present petitioner?
Who is the wife of the informant?
Petitioner. Petitioner, absolutely.
Informed oblique petitioner.
Yes.
Right on. While order dated 25/7/2023, the trial court has rejected the said application. Full stop. The prosecution has not challenged the said order. However, the informant of the present petitioner has challenged the order dated 25/7/2023. Mr. Ragada appears for the state and submits that he has no objection if the application is allowed. Application is who is the accused?
The accused is Abhay Naik.
He is there. He is appearing.
No, they have not made that party.
You will not he is conceding. You will not make accused as a party. How can I allow?
Party karega.
Who will oppose you? Accused will oppose you?
Yes.
Then? These are minimum thing you don't do.
Yes.
Write down. Then consequently the petitioner submits that he may be granted leave to implead the accused in the present case. Accused in the present case, the permission is granted. He may implead the accused as the opposite party number 2 in the court, countersigned by him, and issue notice to the opposite party. Returnable issue.
May permit your lordship one thing. Your lordship.
Notice you.
Master, no,
Will you not?
Yes, I oblige. Only one submission only.
What submission?
On 5th March, your lordship, the date has been fixed, your lordship.
I will not help you because you
only
you
for
are so
one
callous in-
taken one adjournment, your lordship. Only that.
The prosecution is with you. Prosecution is with you.
Yes.
Shall I write that it's a collegiate petition and dismiss it?
No.
Then?
I know. Like.
Please, these are minimum things you don't do. Then how can the court help you? Do it immediately.
Only that. Yeah. Yes, your lordship.
Then consequently the petitioner submits that it is fixed for what?
Fixed for argument, your lordship.
313 is recorded.
Yes, your lordship. Argument. For argument.
Neither you are sure about it.
No, I am sure. For argument, your lordship. For
Statement has already been recorded.
Yes.
Shall I record it?
Yes. My friend is also present for posted on argument.
Statement has already been recorded or
Yes,
not?
ma'am.
Yes.
It is recorded.
Ma'am.
Do you have the date?
On 5th March, this is posted for argument.
Then consequently the petitioner submits that the matter is fixed for final argument. Therefore, he would be moving an application for adjournment before the court below. Court below. He may do so if such application is moved. The plaintiff will petition to the application on its own merit, owing to the fact that the matter is subject to court.
Yes. Deep progress.
Why are you damaging your own case? I don't.
No, your lordship. Only that, your lordship, my prayer, small prayer, because.
Who will be affected by these orders? Accused will be affected. You don't impede the accused. Anyway.
Deep progress.
I plead your lordship.
Yes.
So it's an application for cancellation of bail. The informant is before your lordships.
You are the informant.
Yes, I am for the, I am for the
What is the
opposite.
offense?
Lordship, the offense is 376 2N, 341, 323, 506 and 34 IPC. Here, the learned additional session judge allowed the bail application of the petitioner, the opposite part number 2.
When the bail was granted?
Bail was granted on 10/6/2022. I have stated in paragraph 4.
10?
10/6/2022.
Why should I interfere in this case?
The Lordship is threatening the
Has he violated any bail condition?
No, yes, sir.
Earlier occasion asked me to take instruction and instructions so far I have got it instruction the IIC Kujang PSA submitted report. I am to submit that I verified the CCTN model as well as a crime record and ascertained that since the date of a bail order, that is since 20/6/2022, no complaint has been filed against the.
Then
complaint has
there
not
is no
been filed.
violation of the bail condition. He has already been granted bail in 2022. Today we are in 2024. Why should I cancel it?
Since he is threatening, that is why I have filed the.
There is no complaint. That's what the police say.
Yes, I will file complaint later on. Before the IIC.
My lord, my instruction.
Here.
My lord, my instruction is that trial is concluded. Case stands for argument and judgment.
On the basis of the statement of the state counsel, your lordship.
Right. On the petitioner is the informant. And he has moved an application for cancellation of the bail granted to the accused, which was turned down by the court below. Therefore, he seeks intervention of this court. Then counsel appearing for the accused, opposite party number 2, submits that the trial has already been concluded and the matter is at the final stage. In view of the Mr. Ragada IPS for the state and submits that indeed there is no complaint filed by the informant regarding any violation of the bail condition, and the written instruction is taken on record. In view of the aforementioned, the petition is dismissed. Taken record.
Obliged, madam.
Next.
Yes.
42. 42.
Lordship, on behalf of Mr. Chand, Lordship, may I please? Lordship, previously we have appeared before this court, Lordship, and we praying for adjournment for week, Lordship. We'll file counter, Lordship.
You are for opposite parties?
Yes, Lordship. Opposite party too.
Mr. So enters appearance on behalf of opposite party, seeks time to file the response. Time is granted. Adjourned. Yes.
Deeply obliged.
43. 43.
May I please, my lords?
Yes.
My lord, this CRLMA file, my lord, against the orders, that is annexure 3, page 18, my lord. The all condition are imposed by the court below while granting bail. This bail granted by court below to the petitioner 408 CRP IPC imposed a condition which petitioner is impossible to pay cash including, for which petitioner again taken to custody. Lordship, kindly have a glass.
You have other remedies.
Say condition ta mu waived out pai aschi, my lord.
Condition you have to go to that court only, which has.
Na seta ba se ei court ga se pade, that is provision, my lord. Provision answer ei Hon'Ble High Court will waived out the conditions.
No, that's right, but you have to go to the same court.
My lordship, kindly have a glass, my lord. So
That's right.
annexure 3,
Submit that.
annexure 3 page.
Ramesh Kumar, which is in the.
I have two in this regard, my lord. Running page 20, my lord. Se bail grant करथिले 10,000 टका प्रति मास देकी bail जिबु. A petitioner is a student.
You want variation of that order?
My waiving
Go
out
to
of
that court.
particular the one condition.
You don't understand what I'm saying. Which court has imposed this?
That additional sessions is Barampur.
Have you gone there? Have you moved an application before that court saying that the condition is onerous and I can't comply with the condition? Have you invited an order from that court?
The condition, my lord, they change the forum which my lord Hon'Ble High Court. Your lordship may ask me, lord, my judge, you are waiting on. Since my lord last, my lord, I have tendency of Odisha High Court practicing, my lord. that that is the CRLM is the
So
appropriate.
tendency and practice and all these things will not come in the way when the law.
Bail ହେଇଯାଇଛି ଖାଲି condition ଟା ଦେ bail granted below.
Go see, there are provision in the under the act. Why don't you go and what is the
ଏଠି ଆମର forum ହଉଛି ବା ତାଙ୍କ condition ବିରୁଦ୍ଧରେ CRLM ଆମେ High Court is the only forum, my lords. The lords may ask government council, they can better your lawsuits. Page 20, my lords.
why is this condition?
Well, the condition.
Ideally, he should go move application in the same court for variation of that. But since the bail has been granted, why unnecessary? He has already come.
Yeah, custody, my lords.
What is the condition?
My lord, page 20, that is last like paragraph 6 last.
No. Why this condition imposed, my lord? And paragraph 5, my lord.
You call sorry.
Okay.
Sir, page 20, my lords.
Yes, I am on that.
That the petitioner shall appear in court and deposit money each month once to the informant which receipt he shall file, and the minimum deposit would not be less than 10,000. Petitioner is a student and my lord is preparing, my lord, exam that is I file, my lord.
What is the allegation against you?
Allegation 408 I is working in the clinic, private clinic, that he had taken from the informant regarding its distribution of medicine 10 lakhs rupees. This is the allegation. But
he has fixed the.
no, therefore, my file last occasion the receipt file kaji. Petitioner is not the employee of the clinic. Last occasion I filed the receipt, my lord. Lordship kindly have a glance. Order dated 24/7/2024 फाइल करछि.
Want to pay lump sum? Don't want to pay.
ମୁଁ ପାସେ
return କରିବୁ କହିଛି ଦେନ ଲାଇନ ସେଇଟା
ନା ନା ସିଏ ସେ କ୍ଲିନିକ ର ଏମ୍ପ୍ଲୟି ନୁହେଁ. wrong FIR has been lost.
Matter one line I read out. Petitioner accused said he was ready to return.
আর জেলে পସିବା କଣ କରିବ? ଜେଲେ
You have considered that I'll pay.
আর ଜେଲେ ପସିଛି ମାନେ
And once you, that's right, but what to do? Why?
Lordship kindly consider the মানে petitioner situation.
I'll record your statement. I will relegate you to the court below to alter the condition. Let us follow the procedure.
ଆପଣ observation ସେଇ ଲାଟା ଦେଲେ ମା ପିଲାଟା ବାହାରି ଯାଏ student time.
And that also I'll try. But go to that court and ask for bail. I'll write that. The petitioner has challenged the order dated.
এটা ଗୋଟେ ডেট চার্ট মতে কইଥିଲା ମୁଁ ଦେଇ ଦଉଛି.
Order dated 9/9/2022.
Date chart.
Whereby, although the petitioner has been enlarged on bail, but certain conditions have been imposed by the court below.
Cash condition.
While granting bail.
Condition number 1.
Agreed by
Condition
number 1. Whereby the trial court has asked the petitioner to deposit 10,000 rupees every month. 10,000 rupees every month. When it comes to the petitioner submits that the petitioner is a student. Despite the fact that he has been granted bail, he could not come out from the custody because of the onerous condition. I am of the considered view that the petitioner should move appropriate application before the court below for variation of the condition.
ଡେଟ୍ ଚାର୍ଟ ଅନୁସାରେ ଅର୍ଡର ଡାକି ଦିଅନ୍ତୁ ଭଲ ହବ. ଏଇ ତାରିଖ ଯାଇଥିଲା କୋଉ ତାରିଖରେ କଣ ହେଇଥିଲା?
ଆପଣ ଗୋଟେ ଅର୍ଡର ଲେଖି ଆଣୁଛନ୍ତି, ସାଇନ୍ କରିଦେବି ସରିଲା. Variation of the condition. Taking into consideration the fact that the petitioner is in custody from
custody initially arrested 20/7/22. Thereafter my lord in individual issued 18/9/23.
since 18/9/23 ରୁ custody ଅଛି.
ଆଜ୍ଞା surrender କଲି ପୁଣି. individual issue କଲି.
Taking into consideration the fact that the petitioner is in custody since 18/9/2023 and the petitioner is a student, the court below should consider the application to be moved by the petitioner for variation of the condition with the same liberty. The petitioner is disposed of. You move the application. I have recorded. You are student and everything else.
Student ଆଉ ଗୋଟେ ଲାଇନ କୁତ୍ର permission ମିଳା that the petitioner not the employee of the clinic ମତେ false FIR ଦିଆ.
Petitioner
not the employee.
He is a student and he claims that he is not the employee of the clinic.
Indirectly,
Everything I have said, but follow the
ଆରେ
procedure.
ଆପଣ କୋଉଠୁ ତ ନେବୁ ଆଉ କୋଉଠୁ ନେବୁ ଆଜ୍ଞା ଆପଣ ମୁଁ ଭାବିଥିଲି ଏଇଠି ଡାଇରେକ୍ଟ ନେଇକି ପଳେଇବି ବୋଲି
But sometimes leniency should not be misused also.
ଆଉ ସୁପ୍ରିମକୋର୍ଟ ଜଜମେଣ୍ଟ ମଧ୍ୟ ମୁଁ ଅର୍ଥ ଦେଇଥିଲି ସୁପ୍ରିମକୋର୍ଟ ମଧ୍ୟ ଦିଟା ଜଜମେଣ୍ଟ କହିଛନ୍ତି କ୍ୟାଶ ଇମ୍ପୋଜ କ୍ୟାନଟ ବି ଟେକନ୍
But sometimes,
That is the view of this court.
that amount should not
I am also of the same view.
ଆଜ୍ଞା that amount should not be rejecting the bail application
Although this court saying that.
You move the application. I think it will be done now.
ଆଜ୍ଞା
If he doesn't do, then he come.
ଆପଣ ଆଉ ଟିକେ ସେମିତି ଲେଖିଦେଲେ ଦେଇଦିଅନ୍ତି ମତେ
ହେଇଗଲା ପରା?
ଲେଖିଦେଲି, ସବୁ
ଆପଣ କହୁଛନ୍ତି ଦେବେନି ମୁଁ ଭାବୁଛି
ସବୁ ଲେଖିଦେଲି।
ହେଇଯିବ।
ଆପଣ ଯାଆନ୍ତୁ, ହେଇଯିବ।
ଆଜ୍ଞା problem
40?
44.
Item 44, your lordship, on behalf of Advocate Mr. Satyanarayana Mishra, I prefer passover.
Pass over.
I prefer adjournment.
Adjournment marks.
Opposite party number 2 pages.
He is appearing for opposite party number 2, 6 adjournment.
11 March ko
Mr. So-and-so enters appearance for opposite party number 2 and 6 an adjournment to file his response. Adjourn to. Adjourn to.
I'm filing an affidavit. I'm filing an affidavit, maybe kept on record, your lordship.
Okay, he files objections by way of affidavit taken on the court. Objection.
45.
Yes.
Please, my lord.
Yes.
My lord, the order passed by the Lord and JMFC Nimapada is under challenge. My lord, here, the Lord and JMFC Nimapada that please to convict the appellant, the accused person, the present petitioners, under section, my lord, that 294.
You have come against the sentence.
Yes. No sentence has been awarded. Only 1,000 rupees penalty has been imposed one of the petitioner. Yes. In the last occasion, my lord also observed, wanted to know whether that 482 is maintainable or not.
That's right.
Yes. Basing on the order.
Sentencing order, wrong, right, whatever.
No, no.
You have to go to other.
No. The basing on the order passed by the Honorable Apex Court, 482 is maintainable. Again.
Against sentence.
Yes.
Conviction and sentence.
No. That was argued.
3 persons convicted, my lord.
No one is.
2 persons convicted.
Yes.
One person's.
Let us understand.
2% religion PO Act, my lord. Probation of Offenders Act, my lord. So, but this petition is concerned, my lord, that has not been given to the petitioner as well. There are some materials against the petitioner, my lord, the report call for from the.
His application under section 12 is not accepted.
For that, then the while convicting him and the sentence, though there is no such sentence, my lord, but
yes, only 1,000. Fine 1,000 rupees.
3 counts, my lord. So far, 294, 1,000.
Essentially, you are challenging the conviction
My
and
lord.
sentence.
Yes.
Why? How 482 maintainable?
Yes, that is.
Though appeal not maintainable, he has to file revision.
No. That is maintainable. That is maintainable, sir. 227, sir. 3 under section 376 CRPC.
Which paragraph you want?
Sir, I have given a red mark. Paragraph 6, sir. Law and counsel appearing for the appellant has assailed the impugn judgment mainly on the ground that the discretion vested in the High Court under section 482 of the Code of being very wider in the instant case, the High Court grossly erred in declining to exercise its jurisdiction on the ground that an alternative remedy is available to the appellant against an order acquittal of accused, relying on the decision of this court in the
This is a different.
Alternative remedy, this court in Asim's Sawalani Marchani versus
See, in this case, what had happened, I tell you. One of the co-accused person is acquitted. He says that on the basis of the acquittal, you pass an acquittal order.
No.
So says 482, you go to.
That was a dismiss, non-appearance, that was matter was stand dismiss, sir. May I read out the total A, then my lord? Yes.
I'll give you liberty, and why don't you go?
No, my lord, only 480 in other occasion also the matter was concluded, the argument by before another bench, and also the case was also.
By the time, if you would have gone to the other court, you would have got the indulgence. Unnecessary by wasting time. I don't know. Anyway.
No. Anyhow, 482 is maintainable, sir.
Why are you fell in love with 482 what?
Here is a petition under 482.
For everything.
No, that is, sir, that is
482.
the wider jurisdiction.
When the
Tikam koisar, tike apna koibe tabar kichh nahi, sir.
Okay.
376 CRPC 376, no appeal in the petty cases, notwithstanding anything contained in section 374, there shall be no appeal by the convicted person in any of the following cases where a high court passes only a sentence of imprisonment for a term not exceeding 6 months, or of a fine not exceeding 1,000 rupees, or of the both such imprisonment and fine. B, where a court of sessions or a metropolitan magistrate.
Where are you reading?
Sir, 376 CRPC section 376.
You are reading the judgment, right?
No, that is CRPC.
Let us complete the judgment.
Sir.
I'm searching what I want.
No, sorry. Sir, paragraph 6, sir. Paragraph 6, it is very clear that the Lord and Counsel appearing for the appellant has assailed the impugned judgment merely on the ground that the discretion vested in the High Court under section 482 of the Code being very wide. In the instant case, the High Court grossly erred in declining to exercise the jurisdiction on the ground that an alternative remedy was available to the appellant against an order of acquittal of the accused. Relying on the decision of this court in the Asim Sahabani, Merchant versus Bridgemeher and another, the Lord and Counsel has urged that having regard to the serious nature of the charges against the respondent, the complainant should not have been dismissed in default on account of the non-appearance of the complainant who had been otherwise exempted, that is, from the personal appearance, and the case ought to have been tried on merit. In support of his contention that the dismissal of the complaint.
What is the proposition in this judgment?
482.
That merely because an alternate remedy is there. 482,
Yes, that is
482 cannot be, the remedy of 482 is not closed. That's what you want.
Yes, sir. Yes.
That's right. But here, this is a case of conviction.
conviction.
Sir, dismissal. Case of a dismissal. Non-appearance case was dismissed. Yes. It is argued that having regard to the nature of the case, the High Court committed a patent error of the dismissing the petition under section 482 of the Code on the ground of availability of an alternative remedy. In support of the prosecution, that availability of an alternative remedy or C is no ground for dismissal of an application under section 482 of the Code.
Where is the interim order given to you?
Yeah,
In this
finality. The order itself attended is finality, my lord. Against final order, he has filed before revision.
That is the
Before sessions.
that is the question. 482 is maintainable, sir. 482. I have 482 is maintainable. Please go through this judgment. I'll just give a.
Yeah, what I'll do is,
Sir.
listen, what I'll do is I'll give you liberty to approach the right court, and the interim order which has been passed in this matter shall continue till you avail the remedy. Till you avail. This much I can do.
No, 482 only 482.
I'm giving that protection. You go. Why don't you go and avail?
No, the 482 is maintainable, sir.
According to me, it's not maintainable. What?
The order itself and the judgment order.
I may be wrong. What to do? Write down.
Against finality.
I'm extending the interim order to you. Go and avail the remedy.
Sir, may I request one thing?
You have wasted so many hearings unnecessarily. By now, the interim order is there.
Judgment was also judgment reserved. Or before the another honorable bench, the judgment was also reserved. Same argument was also advanced before the honorable court. Honorable court, please, this is that the point so far the maintainability is concerned, that was also over, and judgment was reserved. Thereafter, it was also released. Again, the matter has come.
Right. The petitioner has challenged the order dated 27/4/2023 in GR case number so and so, corresponding to TR case number so and so, page 10, so and so, whereby what had happens, whereby that is 20. What is the impugn order? Yes, whereby the petitioner has been convicted and convicted for offense under section
294,
506, 429.
429 RPC
and section 11 of the Prevention of Cruelty of Animal Act.
Okay. He has been awarded a sentence of
fine.
Only fine of 1,000 rupees for appellant number 1.
1 count 1,000. Second offense, my lord, 5,000.
Right down.
And 429.
That is
500. And also
that is only for petition number 1.
Petitioners. petition.
petitioner.
Only petition number 1 defined.
Petitioner.
तीन जन अछन हाँ फाइन पे तेणु कहिछि
कौन हला आपण मु किछ यूज करनी आपण निजे निजे କଥା ही सब कर दो डिसाइड
Three petitioner there, my lord.
Yes.
Against only fine imposed.
fine was imposed only against of petition number 1.
Convicted under section petitions were convicted under section and petitioner number 1 is levied the final imposed the fine of rupees 1000.
1000.
Whereas what happened to 2 and 3?
But they have any religion fee over.
Whereas
Probation of offenders.
petitioner 2 and 3 has been granted the benefit of probation of offenders.
And one thing, my lord. So far 294 1000 and 506 500 and 429 1500
and section 11 of the prevention of cruelty to animal my lord.
आपण लिखि दियंतु the petition number
page number 36 अछि
page number
36 रो पड़ा अछि
36
hearing of the question of
number 36 is there. The petitioner has been imposed the fine in the following manner. Properly clear and 2 and 3 has been granted the benefit of probation of offense. Full stop. Okay. When the matter was taken up for hearing by the coordinate bench, where is the interim order? Where is the interim order?
There was an interim order.
Which order?
अच्छी
Yes.
That's my lord 5/9/2023 my lord.
When the matter was taken up for hearing by the coordinate bench on 5/9/2023, interim order was passed. Interim order was passed for no coercive action. Interim order to the effect that no coercive action shall be taken against the petitioner was passed. Next paragraph. Let the counsel for the passed. Next paragraph. I am of the considered view that since the present petition is directed against an order by which the petitioner are convicted and various sentences are imposed, the petitioner should avail the remedy, alternate remedy available to him under the law. Let it consider the petitioner at this stage seeks to withdraw the petition to avail the remedy under law. However, he submits that, however, he prays that the interim order passed against parts in his favor may continue till he files the appropriate petition challenging the imbue order. But if the present petition is dismissed and withdrawn, to enable the petitioner to file appropriate proceedings before the available forum under law. Till then, the interim order passed by this court on 5/9/2023 shall operate. Interim order continue, you go and
so but 2, 3 are concerned, he may challenge matter to PR.
Whatever.
46.
Yes.
46.
46. Pass over.
47.
47. Pass over.
48.
Yes.
Wait, 48 both the item with not pressment.
48.
48.
Where is the memo?
Just file.
Give it, you give the memo.
Mal.
Where is the memo?
Sanction file the file कर दो.
You have that in your file.
Mal.
Give the 48 withdraw.
49.
Both the matter. Huh? 49. Yes.
I will kindly see the last order passed by your lordship.
The last proceeding, you also directed to serve the copy only one case they have the copy, the second
The other case has become infructuous. My lord, at the outset, I had submitted that day, my lord.
The other one.
The other one, that is
1630.
1630, that has rendered infructuous.
The petition submits that in 1630.
30.
The matter has become infructuous and dismiss the matter. The petition is dismissed as being infructuous.
Now we're
Yes.
I think it is my petition I should address first.
No.
My learned
Let us see
friend
what
can-
was the order.
My Lord, may kindly see the order. Wait for your turn, please. My Lord, issue notice, Mr. So and so, learned government advocate appears and waives on notice on behalf of opposite party number one.
Yes, I understood.
And then, my lords, pursuant to your lordship's order, my lords,
Now.
there's no.
Mr. Bhatt. Mr. Bhatt, since you are appearing, it's good that you are appearing. So I need not waste much more time in this matter.
On the last occasion, your lordship had directed to have a settlement.
Why
It cannot be, because the way they have assaulted me and it is incurable. And furthermore,
I was not expecting this from you.
No, my lord.
You are there means things will be done.
No, my lord. Furthermore, now discharge petition has been rejected. After this, can it be? Your lordship can you see?
Not by us, not our petition.
1 minute. No, I am not aiming at this case. I am aiming at the
FIR number 306.
entire dispute between the builder and the people, those who are staying there.
Not builder, my lord. I am a scheduled caste person. I have been assaulted brutally. If your lordship will grant me some time, I will produce the bloodstained photographs and the injuries. Then your lordship may say anything. Man, I have nothing.
No, I have to hear it.
Furthermore, after submission of charge sheet, they filed the discharge petition and discharge petition has been rejected.
Perhaps, my lord, my learned friend is confusing the other accused persons with my case. My lord, I have not filed any discharge application. My name was added by way of 161 statement, my lords. So, your lordship, my case, I was not even present at the time when the assault took place, about which my learned friend is mentioning. So, there are two aspects, my lord, of the same case. 306, the FIR was lodged against the persons who participated in the scuffle, and in which both the sides got injured, and then a cross FIR was filed. I am the secretary whose name was included in this on the basis of statement of 161 statement, and I'll demonstrate to your lordship. My presence was not there. It is an admitted fact. And in 161 statement, what they say, I'll just take your lordship through that. That in the evening at 5 p.m. when I came back to the society, I'll show to your lordship. When I came to know that all these things had happened, being the secretary, I just made a comment that I will not allow this person to enter, and if he comes, I'll see that what happened. Apart from that, there is nothing.
You have not participated in
nothing. I was not there. That's an admitted position. The charge sheet itself shows. This is a case, my lord, where I'm squarely covered by Bhajanlal subsequent judgment, and this is a fit case, my lord, where nothing has been assigned to me. Nothing. And I'll demonstrate it by showing the relevant documents, my lord. What my learned friend is referring to are those persons, those residents who participated in the scuffle, where this 307 other things are there. The charge against me is under 294, 341, and 506. I'll show to your lordship, ingredients are not met at all after showing the allegation against me. So if your lordship may just permit me, my lords, I'll just...
what is the FIR against you?
Please, my lord. The FIR I am not named, my lords. I am not named in the FIR. That is an admitted position. I'll just show your lordship.
How you...
yes, my lords. May kindly see... Yes, my lord. May kindly see that thin additional affidavit, my lords.
You were brought in the charge sheet.
I am brought in charge sheet by way of this 161 statement, which I'll show to your lordship, is ad verbatim the same, recorded on different days, but comma, full stop, everything is same. May kindly come, my lords. This thin paper book, your lordship, may kindly see. Page 10. May kindly come to page 10, my lords.
Yes. Who is the informant here?
Mr. Ganesh Malik. So I am...
His statement is at page 9.
Page 10, my lords. Page 9 is the copy of the FIR. Now, I am not named here. Now, may kindly come to page 10, my lords.
Okay, this is the FIR.
160. This is 161 statement.
Okay. No. This page 9 is
the FIR, my lords.
Okay.
Yeah, I am not named.
Yes.
Now, your lordship, and if your lordship may kindly see, I can identify people who tried to kill us. So the persons who are named here, this is the bonding thing. My lord, may kindly take note of the fact that the incident occurred at 11:30 a.m. on 1/11/2023. Now, your Lordship, may kindly turn over page 10, my lords. Lords, you got it? Now, my statement before you that today, I'm reading fourth line from the top, my lords. 1/11/2022 at 11:30 am, Sibhat Hota, your Lordship, may kindly make note of that. I am Bidhu Bhushan Nayak. Now, Sibhat Hota, Pada, so and so, Patra Nayak, so Dobhi Nayak, and others, including myself, while working the Z1 phase 2 under the instruction of our owner and Z1 manager, were along with other labor and went to the stockyard near the so and so with tractor to bring construction material. While loading the material, some uniformed security personnel obstructed the work and abused us and asked us to stop the work. For saying that we are on duty, Z1 Resident Association Secretary Malaya Panigrahi, Sanjay Patra, Akhilesh Parida, Secretary Guard Sujit Kumar Behri.
Name is not.
So I am not there. Now, my lord, may kindly come to last four lines.
Yes.
Therefore, our staff took us to the hospital for treatment. So they all went to the treatment. Now, later, my lord, may kindly take note of this. Later in the evening, Bidhu Bhushan Nayak, that is the petition before my lords, of Z1 phase 1 Resident Association arrived and said, let us see how that Tapan Mohanty would work here.
Tapan Mohanty
is the builder. Is it promoter, builder.
Okay.
Now, my lords, my learned friend has told me that in Odia, only one word is missing here. And that is, it said that let us see how that Sala Tapan Mohanty would work here. That the word is Sala.
Okay.
Only that is the only word. And issued a life-threatening warning to anyone approaching this location. Now, because of which we are in a state of fear. Now, this statement, according to them, is made in the evening when I come back to this society. Then, while we were on our way to report the matter to the police station, Bidhu Nayak threatened us on the road in front of the police station. Even before this, they have fought with us and threatened us while working. This is my true statement. Now, my lord, may kindly take note of this fact, my lord, that this statement has been recorded on the same day, 1st of November 2022. And then your lordship may kindly turn over to page 12. Add verbatim the same. If you're the last two lines, page 12, my lord have got it.
Yes. Thereafter our staff.
वो आपके पास नहीं है वो सबकी वाली इनको दे दो कॉपी. Later in the evening,
161, Mr. Maharaj.
161 page.
Translated.
हाँ, translate हिंदी समझ आता है.
Page 12, statement of Dhubey Prasad.
Addition. Now, your lordship may kindly come to page 12, last two lines.
Yes, I have seen
that. This is ad verbatim. Now this statement is recorded on 111. Then
14.
Then my lords 14 ad verbatim the same. Then my lords even then your lordship page 15 ad verbatim the same. Page 16, and then your lordship may kindly come to page 17. Now this is recorded on 2nd.
Next day.
17th of the 2nd of November 2022.
Okay.
That's page 17.
Yes. What does
Later in the evening, my lord, see, thereafter other staff took the injured, page 17, the 13th line from the top.
Thereafter
other staff took the injured workers to the hospital. Later in the evening, Bidhu Vidash so and so arrived, said, let us see how that Tapanma would work here, and issued a life-threatening warning to anyone approaching this. I have heard Bidhu Nayak threatening them when they were on their way to report the matter. Even before this, the above named person, they have the fight, so and so. Then your lordship may kindly come to page 19. Now, this page 19, my lords, may note, this statement is recorded on 17th January 2023, 17th January. Here also, my lords, just see the last 5 lines, your lordship. Later in the evening, Bidhu Videj Nayak and of Z1 phase arrived and said, let us see how the tribunal works. And I have heard, so ad verbatim the same. And then lastly, my lords, page 20. This is on 10th of November 2022. So, my lord, what my submission is that ad verbatim, full stop, comma, the same, parrot-like statement. Then your lordship may kindly come to the charge sheet, my lord.
Yes.
Now, the charge sheet, my lord, starts at page 64, 60, in fact, 59, may come to page 65, my lords.
65.
And if your lordship may kindly turn to page 66.
Yes.
66, my lord, may come to 14th line from the top, my lords.
Yes.
Well, at about 5 p.m. My lords got it?
Yes, at about 5
At about 5 p.m., Bindhu Bhushan Nayak, that is the petition before my lord, arrived here. He also abused in vulgar languages. Now, this is, he also abused in vulgar languages to Tapan Mohanty and his workers, while other workers were on their way to PS to report the matter, but then threatened the workers for dire consequences. Now,
Tapan Mohanty was
I'm so grateful, my lord. No, he was not. My lord, the entire incident occurred at 11:30 a.m. The allegation against me is at 5 p.m. when I came back.
Yes, Mr. Maharaj.
Yes, my lord. But the translated copy filed by my seniors, I will not repeat that. I will straightway go to the statement of the witnesses and the statement of the complainant. But the two lines, I am reading from the statement of the complainant, Ganeshwar Malik, who is a scheduled person. ଏହା ପରେ ଆମର ଷ୍ଟାଫ ମାନେ ଆମକୁ ଚିକିତ୍ସା ପାଇଁ ଡାକ୍ତରଖାନା ନେଇଗଲେ। ଏହାର କିଛି ସମୟ ପରେ ସନ୍ଧ୍ୟାରେ Z1 phase 1 ରେ ରେସିଡେଣ୍ଟସ୍ ଆସୋସିଏସନର ବିଧୁଭୂଷଣ ନାୟକ ଆସି ପହଞ୍ଚିଲେ
ହସ୍ପିଟାଲରେ
ନା ସେଇ ପ୍ଲେସରେ। ଓ ସେ ସ୍ଲାଙ୍ଗ ଲାଙ୍ଗୁଏଜ ତପନ ମହାନ୍ତି ଏଠି କେମିତି କାମ କରିବ ଦେଖିବା, ଯିଏ ବି ଆସିବ ତାକୁ ଜୀବନରେ ମାରିଦେବ ବୋଲି ଧମକ ଦେଲେ, ଯାହା ଫଳରେ
Tapan Mohanty is an SC. Tapan Mohanty is an SC or ST? What?
No, Tapan Mohanty general, but the complainant is SC.
But he had already gone to the hospital. All these things in the evening happens there in the Z1. He says that I have taken to hospital. He was not there.
Yes.
So how he, to whom he is scolded?
But apart from that, three SST, so far 3 SST is concerned, it may be goes. But question is whether their consequences giving threaten, whether that part will go. That is the, because 34 is there. How, then what they did? What they did?
34 indeed. That is 34 relatable to
Not
7
against
o'clock
them.
incident.
34 is not, my lord. Is not.
How this language, my lord, again, ଜୀବନରେ ମାରିଦେବା ପାଇଁ ଧମକ ଦେଲେ, ଯାହା ଫଳରେ ଆମେ ସମସ୍ତେ ଭୟଭୀତ ଅବସ୍ଥାରେ ଅଛୁ। ଆମେ ମାନେ ଏ ବିଷୟରେ ଥାନାକୁ ଜଣାଇବା ପାଇଁ ଯାଉଥିବା ସମୟରେ ବିଧୁଭୂଷଣ ନାୟକ ଥାନା ସମ୍ମୁଖ ରାସ୍ତା ଉପରେ ଆମ ଲୋକମାନଙ୍କୁ ଧମକାଇ ଦେଲେ। ଏହା ପୂର୍ବରୁ ମଧ୍ୟ କାମ କରୁଥିବା ସମୟରେ ଅନେକ ବାର ଏମିତି ଗଣ୍ଡଗୋଳ କରିଛନ୍ତି ଓ ଆମକୁ ଧମକ ଚମକ ଦେଇଛନ୍ତି। Apart from that, this statement has been corroborated by other witnesses and he is having criminal antecedent.
How many?
Not a single, that is my lord, criminal antecedent is, my lord, he is having
Two cases, my lord.
2 cases are there.
One defamation.
Infocity PS case number 201 of 2022 under section 147, 148, 294, 323, 149 of IPC. Then my lord, Infocity PS case number 308 of 2022 under section 294, 353, 332, 506/34 of IPC. So government assaulting government officers, not permitting them to do their duty on proper way, and that is his credit. It goes to his credit. So these are the documents. Admittedly,
That what you mean say the threatening part.
Yes, that.
And getting these people got scared.
Scared, yes.
Owing to the fact that he has a criminal antecedent. That's what you want.
This, including this, I am not, my lord, I am not separating this. If separate, then 506 is there, my lord. So this will take into consideration because in front of the police station, he was blocking the people not to lodge the affair, given threatened. That is there. So now this is supported by the other independent witnesses. Now, question is whether 3 SST, your lordship is rightly holding this, whether 3 SST will applicable to him or not. If the individual he will be considered, then that will not. This is my fair summary.
What my learned friend is.
What is the stage now? Charge sheet is filed.
Charge sheet has been filed.
Cognizance has been taken. And what my learned friend is saying is not part of the charge sheet. Whatever he's saying, my lord, is not on record.
No, the antecedent.
Antecedent. I must myself submit before my lord.
Now the problem, I'll tell you. The problem is mere threatening, may not threatening in the air may not make out a case of 506. But owing to the fact that you have a antecedent, criminal background, you are giving threatening to someone, they are bound to get scared. That is the
my lord is absolutely right.
Yes.
My lord is absolutely right. If that be so, my lord is absolutely right. But let me just submit, my lord. So far as this 308 is concerned, which my learned friend referred to that FIR, when is that FIR? So my lord may kindly make note of this. 306 is the first FIR, which is lodged by my learned friend's client. 307 is the cross FIR lodged by the residents, the cross FIR against them. 308 is an FIR which is lodged against me. Why? Because when they were not writing this 307, I being the secretary of the association, I was only insisting on the SHO and IO to write the report of 307. So my lord are very well aware how this police functions. So
all these cases.
Yes, they are all interlinked.
Yes,
yes, my lord. I'm absolutely, my lord. And the other case which my learned friend is saying is, my lord, is of defamation. That is in 2022. This is criminal defamation which is going on. So nothing to do with this.
Now 353 is there.
500. And my lord, may kindly come to page 67. My learned friend again is not right, my lord. He says, I am not roped in by way of 34 at all. Now, my lord, may kindly see 341, 294, 506, page 67. And under, my lord, fourth line. And under section 341, 294, 506 IPC against accused person, Bidhu Bhushan Nayak. Now, your lordship may kindly.
Where have you read it?
I'm sorry, page 67.
Yes. 67.
Now, it says, Akhilesh Parida, Sujit Dehri, Topan Sethi, and so these are the person. If your lordship may see the top of the page, 341, all these things are 34 is there.
Yes.
Now under section and then my lord, under section 341, 294, 506 IPC against accused person Bidhu Bhushan Nayak. Now I pause here for a minute. Your lordship may kindly. I'll just
so you are not roped in that ACST?
No, not at all, my lord. And your lordship, except this, and your lordship may kindly, I'll just trouble your lordship may kindly see 294 of the IPC, my lord. I'm sorry, my lord.
Yes.
It is necessary because
what is
none of the ingredients of 294, none of the ingredients of 341. My learned friend may kindly permit me to finish. You will have to discuss.
Yes.
None of the ingredients of 294 is made out. None of the ingredients of 341 is made out. And 506, my lord, I'll take your lordship to the apex court judgment, my lord, Justice Pardiwala's recent judgment, where he says that mere abusing or mere shouting does not constitute the offense under 506. That's the latest one which I have got, my lord. So my lord, may kindly see 294 first. Your lordship may kindly take note of the fact that in the charge sheet, I'll once read those 3 lines again, my lord, because at about 5 p.m., I'll just read those 3 lines, my lord, and then I'll take your lordship to it. At about 5 p.m., Bidhu Bhushan Nayak of Z1 Resident Association arrived there. He also abused in vulgar languages. Now, the statement which your lordship has read, none of the witnesses under 161 says that he abused in vulgar languages. To Tapan Mohanty and his workers, none of them.
The charge sheet is a narration of the fact by the police, whatever has happened.
Please, madam.
It may not reflect the as it is the 161 statement in the.
No, it may not. So therefore, my lord, but they can't improve upon what is said against me.
Right.
But now your lordship may kindly see 294. It says,
290.
please, obscene acts and song. I'm so sorry, madam.
Yes.
294, madam, got it?
Obscene
acts and song. Whoever, to the annoyance of others, does any obscene act in any public place or sings, recites, or utters any obscene song, bawd or words in or near any public place shall be punished with imprisonment for a term which may extend to 3 months. Now, my lord, in none of the statement, including the charge sheet, this allegation is there. It doesn't fulfill the ingredient. I'll again read.
Don't you think that it is not the stage to examine all these things?
No, my lord,
at stage you can argue all these things.
No, my lord.
Who stopped you?
No, my lord. But with utmost, but your lordship in Bhajan Lal and subsequently, the Supreme Court says, my lord, the 482 is exercised in exceptional circumstances. But my lord, this is a case, my lord, where if you read, if your lordship will read the charge sheet, the statements and all, and consider it to be true, even then, my lord, nothing is made out against me.
How you get over 341?
May kindly come to 341, my lord. Wrongful restraint. When I came, there was no one, my lord. Whom will I wrongfully restrain? I'll just read
and 506.
And then 506, my lord, may kindly see. Whoever, it is not their case that I came at 12 o'clock or 12:30, half the people were there and the injured had been sent to the hospital. No. I came in the evening when everything was over. They all had left.
Let us see 506.
Now 506. Whoever commits the offense of criminal intimidation shall be punished for a term which may extend to 2 years. If threat be to cause death or grievous hurt. Now, Your Lordship, may kindly see what was the threat.
You said I'll kill you.
No, may kindly see. I'll just read. I'll not trouble Your Lordship. I'll just read the relevant portion.
Yes.
Later in the evening, Bidhu Bhushan Nayak of Z1 Phase 1. No, I'm reading page 10, my lord. The residence lawyer arrived and said, "Let us see how that Tapan Mohanty would work here," and issued a life-threatening warning to anyone. To whom, my lord? I asked this question to myself. To anyone. What it says is life-threatening warning to anyone approaching this location. अगर कोई भी यहाँ आएगा तो मैं उसको जान से मार डालूंगा. I'm sorry, my lord. If anybody comes to this area, I will kill that person. My lord,
I understood what you.
So my lord.
So according to
in
you,
thin air.
none of these three provisions.
I'm so grateful.
By taking in the face value.
Please.
And, yes, Mr. Bag. Do you want me to go into all these things at this stage and try to settle this?
It is not a mini trial, my lord.
Well, that's
It's
right.
not a mini trial.
Absolutely correct.
So whatever on paper, the prima facie view. On prima facie view and basing on charge sheet, cognizance has been taken. That will be tested in trial. And we will also see for a moment, some persons, some accused person filed application on 227 that has been rejected, not the present petitioner. But fact remains 227.
Against them materials are there.
Whatever it may be. It is a whole trial, not a mini trial. In the trial,
looking into all this.
But my submission is, all the 161 statement has not been brought on record. The Lordship may give me some time, I will bring all the
who all are there now?
Sub statement, I am having all these statement. Suffice to the argument made by senior.
The statements. And there is 294 is made out.
Yes,
and 506 is also made out. And 341. Everything is made out.
Apart from the submission made by some senior.
68.
Paper he cannot say. He is wanting time to get the papers. Papers is with me.
Yes. It is also with me, my lord.
Yes. So question is whether, as my learned senior has pointed out, 294, 341, 506 is not prima facie made out. To what extent, having so knowledge, my senior is having vast experience, under what circumstances 294 will be applicable? Question is number one. And what is slang language? Then it would be defined. What is slang? Whether sala is a slang or is an intelligent word. This is to be considered number one. Number two, giving threat to Tapan in a public place openly, whether it amounts to 506 or not. That is the public place where he was pronounced the word, supported by the statement of the other witnesses, independent witness. Number three, 341. When the people had been to the police station, he was obstructed by the petitioner along with other accused persons. Is it not 341? What more is the ingredients required to be constituted a prima facie case?
Whatever he says.
Yes, my lord. Only from the 161 statement which is produced before Lordship, I will place certain heads. Page 68, your Lordship may kindly see.
68? Okay.
From the bottom.
Yes.
यापर आम स्टाफ माने आमको चिकित्सा डाक्तरखाना रही गले यार किछि समय परे संध्यारे Z1 फेज 1 रेसिडेंट एसोसिएशन विदूषण नायक आसी पहुंचले से सळा तपन महांती एठी केमिति काम करिवो देखिबा जीए भी आसीबो ताको जीवन मारि देबे देबा बोली धमक देले जा पर आमे समस्त भयभीत अवस्था रे अछु आमे विषय थाना को जणाइबा को जाउतिया समय विदूषण नायक सम्मुख रास्ता रे आम लोक मानको धमकाई देले या देन नेक्स्ट योर लॉर्ड्स में काइंडली टर्न टू पेज 93 बॉटम में 93 में जस्ट बॉटम यार किछि समय परे संध्या रे Z1 फेज 1 रेसिडेंट एसोसिएशन विदूषण नायक आसी पहुंचले से काहे जीव आसी जीवन रु मारि देबा पई धमक देले जहा पर हमें समस्त भयभीत अवस्था रछु हम देन नेक्स्ट योर लॉर्ड्स में काइंडली टर्न टू पेज 94 सेम थिंग माय लॉर्ड. Then 95, same thing, my lord. Then 96.
Yes.
So my submission is, so this is to be tested on trial, not in for 48, for 48, 42.
You're right.
So my submission is, and there are other 161 statement also.
How many litigations are there inter se party?
No matter, so far, this Ganesh Malik is concerned, this is one, and in the SDGM code another, nothing more. He was working under the developer.
What are the injuries received by this fellow?
Yes,
What are the injuries?
but there are
3 persons were injured. You also make
No,
kindly
it's
turn to
simple injury or what?
Simple. Page 81.
head injury 3 centimeter to 1 centimeter to 1 centimeter. That is head injury simple.
What
Iron
is the-
rod.
weapon
Iron
of
rod.
offense?
Iron rod. Number second, 3 centimeter to 1 centimeter to 1 centimeter head simple iron rod. Then third,
I'm just exploring the possibility of
yes.
settlement if
Yes,
possible.
exactly. 5 centimeter, 2 centimeter to 1 centimeter
If
head
Mr.
simple.
Wag, it is a residential area and let them live peacefully. Why can't we?
We are trying our best, my lord. After this incident, number of pamphlets were distributed.
So therefore, it is
No, my lord.
precipitating now.
Not there. We have not done anything. Neither myself nor the builder Tapan Mahanti has published anything nor filed an FIR till date except this.
It appears to be that his client, Mr. Singh's client, may be a leader.
Yes.
And you are a builder.
No,
And
that is the
and the residents are
that
suffering.
they wanted to blackmail me, but for that reason they
No,
assaulted my worker.
that's the reason. Taking in the overall view, that's what I was thinking. That can I send it to mediation? You try your luck. If doesn't happen, I'll send it.
I cannot be a bar.
No. So therefore, let us see
My lord.
if you can
Yes,
send it to
yes, yes,
mediation.
yes. Absolutely.
Yes, my lord. Yes.
Absolutely.
My lord, so far as I am concerned, my lord, may kindly appreciate, my lord. May kindly come to page 40, my lords.
I will not further hear Mr. Singh. I'll just tell you. I at the cognizance stage, why should I get into all this thing? I will only try and see that if matter could be settled, I can send it to mediation, and you will be happy to know that Mr. Wag is there. He is one of the most seasoned lawyer. In his intervention, things can work out, and so that at least the resident can see.
My lord, only with Vidhu Sondak, not with others. I will try my best.
Yes.
Well, also is directly.
Yes,
I'll
yes.
try my best.
Yes,
Taking
yes,
into
yes,
consideration,
yes,
taking into the consideration the nature of allegations against the petitioner, that petitioner, taking into consideration, I am of the considered view that the matter could be settled through mediation. And Mr. Wag appealing for the opposition party,
Ganesh Malik,
Ganesh Malik, submit that he will,
I will cooperate.
we will make out all out efforts to see that the matter is settled, and hence, the parties are delegated to the High Court mediation cell to appear on maybe around 1st February, they said 1st March.
1st February হবে না
First March.
বাহারে কাম হচ্ছে রোজ করে
आपके कौन
এনি ডে মার্চ রে
February तक पड़ेगा
মার্চ হবে
के पे कौन
নেক্সট
next means
নেক্সট স্যাটারডে
next is ଆପଣ কোন ତ ତାହେଲେ 9th ତ ଛୁଟି ଦିଅ ପଳେଇବେ ଆପଣ
ହଁ 9 ତାରିଖ ଯିବ
ନାଇଁ
ଦୁଇ ସାରଙ୍କର ଯୋଉ ଦିନ କନଭିନିୟନ୍ସ ହବ ସେଇ ଡେଟ୍ ଟା ଫିକ୍ସ
16 ଆଜ୍ଞା 16
16 sir
16
yes sir 16
but only mediation only Vidhubhushan I will remain
My lord, may kindly,
I am only Vidhubhushan because see there
Yes,
are
sir,
307 not there I
the my lord may also make an observation. My learned friend is ready to make settlement with my client, my lords.
he said that
that very openly
Fine, that's fine.
the petitioner
That is a fair submission, my lords.
only because you were not there at 11 o'clock.
Ma'am, please, ma'am.
11 o'clock, people are assaulted in the iron rod and all. No interference at this stage.
No, I am not for them, my lords. I am not for them also.
To explore the possibility of those settings.
Nine.
Awaiting the mediation report. Meets on 16th, na?
16th.
19th, 20th, 19th, 20th. Yes. I started having hope because settlement because Mr. Bhag is there.
Yes.
I leave it to Lord.
Only one thing that after this, you will not make any provocation or.
No, all this thing will be part of the settlement
Yes.
only.
Settlement ର ସେଇ part ଟା ରହିବ। Obviously.
At least they let the residents stay peacefully.
Yes.
I'm so grateful, man, for the patient hearing. I'm so grateful for it.
Yes.
Back pardon.
The item.
Back pardon.
Adjournment if you want, tell me. Otherwise, I.
Back pardon, Lordship.
Adjournment.
Yes, your lordship has directed for personal appearance of the party because of the compromise.
Oh, compromise.
Yes, opposite party
Upon
residing at Delhi, he will come on fifth.
Your Lordship, item 50 also I seek adjournment only because of the settlement. Let the both the party come. So we can one.
When you speak to him and he'll give you date.
Yes, Lord.
Ah.
Item 50. Your
Back
Lordship.
pardon,
I will
Lordship.
give the date. Item 50.
Yesterday, Lordship, I have got interim bail, Lordship. But Lordship, in ordering person, Lordship, city case and PS case.
ସେଟା ତାଙ୍କର ଟିକେ wrong ହେଇଯାଇଛି।
Wrongly
ମାନେ
typed.
ଆମର type
ଆମ
type।
କିଏ କରୁଛି ଭାଇ? That's the problem is either you write wrongly or
No,
our
Lordship,
staff
I'm,
leave it.
ସେ sometimes ସେଟା ହୁଏ।
କିଏ କରନ୍ତୁ put the file.
Under item 51 to 53, defects are there. I seek adjournment.
51 to
53. 51 to 53.
51 to 53 defects are there. in your-
51 ରୁ 53
Next.
अर्जुन ନା?
Yes.
Let me-
So grateful, man.
Thank you.
କଣ କରୁଛୁ?
Is it after notice? After notice, not a private party is there. I have also talked to the other side council.
There should be any complaint.
No, I have already talked to him.
73.
He is also not present there.
Many time what happens thereafter they
Not so much,
mention
that-
it. in-
that I can understand.
You make sure that.
Not so much.
Yes, 73. Okay. Yes. Pass over.
Pass over item 2.
It's an application for quashing the proceeding on the ground of compromise.
What is the offense?
Annex 3, the settlement affidavit. Allegation 294-506 and 3.
Where are they?
Again?
Notice and not.
Notice and not.
Acha.
Last time it has come, that's
Okay.
why. only.
Issue notice to the opposite party. Number 2. Ragada accept notice for the state. So and so. And then counsel for the petitioner, Mr. Pradhan, then counsel for the petition submits that the parties have settled their dispute amicably. And on the next date of hearing, the petitioner would appear along with the opposite party number 2, taking into consideration the aforementioned, taking into consideration the fact that the parties have settled the dispute, the further proceeding in so and so, which is state till next date of hearing.
Notice ରେ ଯିବ ପୁରା notice ରେ ଯିବ
Notice and further proceeding I state.
ହଁ 4 weeks after election ଆସିଲା
4 weeks. 23. Yes.
May I please, Your Lordship? Your Lordship, the present petitioners are in custody since 7/11/2023, Your Lordship. 7/11/2023.
What is the allegation? And
Your Lordship, allegation against us is a person has been kidnapped, Your Lordships, and
CD is not available. Yes, yes. CD is not available.
Kidnapped and
other accused persons have asked for ransom, Your Lordship. I have been only arraigned in this case. We have been arraigned in this case because we have antecedents, Your Lordship. We have not been identified in the TI parade even, Your Lordship. The victim has given his statement, and specifically he has not stated our name. That is
our name is how many of you are?
2 petitioners, Your Lordship.
Where is the statement? Where is the statement?
Your Lordship, 161 statements we have not annexed to.
Then how? Tell me where from I get that.
I will get the CD, my lord. CD is not available.
Let me.
Yes.
Yes, Your
CD. CD called for. Yes.
Much obliged, Your Lordship.
26.
May I please, Your Honor? The offense is a 302 IPC. The last occasion called for the date of the examination of the witness. Called for the 26.
302. Charges framed at 22.
My lord.
Out of 25 charge sheet witness, 6 witnesses have been
6 witnesses examined.
and delayed
Notice
trial
is the number
due to
9.
non-attendance of the witnesses. But however, neither is it appearing.
The petitioner.
What is the position?
Must be the 26 ର କିଛି କପି ଦେଇନାହାନ୍ତି ଆମକୁ ଏଇଟା ଗୋଟେ କଣ ସବସିକ୍ୱେଣ୍ଟ କପି ଏବେ ଜଷ୍ଟ କପି ଦିଆଯାଇଛି କୋଉଠି ଦିଆଯାଇଛି ଏବେ ତ ଦେଇଛ ଏବେ ଦେଇଛ ନା ନାଇଁ ଏଇ କପିଟା କିଛି ତ କପି ଦେଇନା
Registry is called for the report. Where is the report?
ସେଥିପାଇଁ ଆମେ ଏଠି ରିସିଭ କରିବୁନି 26 ନା
Yes, there is a report. There is a report. Yes, there is a report.
Notice is the mobile phone.
See, it is now listed for 28th of February 2024. 6 witnesses have been summoned. The remaining charge sheeted witness, all the 6 witnesses remain
Examined, and nothing has been deposed any incriminating facts against the accused person.
By 2, examined by this court. Delay the trial due to non-attendance of witnesses. However, this is dated. Pursuant to the order dated 8/2/2024, the second additional district and session judge Bhubaneswar has furnished a report dated 20th of February 2024, inter alia stating that the next date of hearing before the court below is 28th February 2024, and on that day, 6 witnesses have been summoned. 6 witnesses are summoned to be examined. There are only 5 witnesses, including the IO and medical officer, are required to be examined by this court. And the delay in trial is caused due to the non-attendance of the witnesses on the fixed date. How the fixed date? The learned Sessions Court also inform this court that all steps are taken to dispose of the trial as expeditiously possible. Wait after 4 weeks, give it.
Item 46. I think 46 can check no one after minus
36.
46.
Urgent.
Public. 47.
My lord, I am on VC, my lord. 47,
Yes.
I am on VC, my lord. I pray 2 weeks time to fight remove the defects, my lord. 2 weeks time to remove the
Urgent.
defects.
Okay, urgent.
My
Yes.
54.
Yes, 54. Urgent.
55.
Yes.
This is that matter relating to that release of the gutka.
Written instruction which is taken on the court. Now what happened?
Well, the State Council last occasion they filed a letter wherein they have said that high numbers of tax invoices are found to be genuine, others are not traced. Well, they are not providing. If your lordship will kindly come to that invoices, those are in serial numbers. Well, they have also not said as to in whose name these invoices have been. So, the instruction itself is an incomplete instruction. Be that as it may, my lord. Your lordship may kindly come to section 13(2) of the Act, which that cigarette cigarette and other tobacco products, prohibition of advertisement and the regulation of trade.
Read it.
Yes, what I am reading it. 13(2) says, my lord, no package of cigarette or other tobacco products or advertisement material seized under clause A of subsection 1 shall be retained by the officer who seized the package or advertisement material for a period exceeding 90 days from the date of seizure, unless the approval of the district judge within the local limits of whose jurisdiction such seizure was made has been obtained or for such retention. So, my lord, this is a provision where they are required
to get the
get an approval from the concerned district judge. Here, admittedly, they have not. Last occasion also they have admitted that no permission has been taken from the local district judge.
What is that order? 457 order says.
Revision, my application has been rejected.
And revision court also rejected.
Revisional court also rejected. So I am.
What is the reasoning given?
My lord,
what is the reasoning given?
Reasoning given is, my lord, I have not produced the ownership of the truck, and I have not produced the ownership.
What security you can give?
My lord, any security your lordship may, I can give a my lord, indemnity bond of any amount.
What is the value of the
value of the materials is, my lord, it will be around 3 lakhs odd. It will be around 3 lakhs odd.
Your lordship may kindly see page 47.
40?
47.
Yes.
As I again I am repeating the same thing which I have already draw your lordship kind attention that the instruction provided by the investigating officer that these are the up to this are the genuine and up to this no document is found so far the instruction is concerned. Now your lordship kindly turn to page 47.
Yes.
In the present case, my lord, the word start
In the
Yes,
present,
case.
in the present case in hand, the article have not been seized from the possession of the present petitioner, but from the Bolero pickup van bearing registration number so and
He is the
so.
owner of.
My lord, and being driven by one Kamadeva Naik and its occupant Subham Jodia. Petitioner has neither filed any document of the vehicle showing him as the owner of the same, nor has filed any original copy of the invoices of the seized tobacco product with the seal and signature.
Last occasion
No,
also
no.
he had raised that.
You tell me, are you the owner of the vehicle?
Yes, my lord.
What are the documents?
My lord, vehicle. No, I am not the owner of the vehicle. That I had hired that vehicle for the purpose of transportation of this tobacco, my lord. I am not seeking for release of the vehicle, my lord. I am seeking release of these tobaccos, my lord. But even if your lordship will kindly come to section 18 of that act, my lord, that says within 90 days, if they do not give a notice to the either owner or the person from whose possession it has been seized, they cannot initiate a confiscation proceeding also, my lord. I am just now reading that section. If your lordship will kindly.
First you read 13, 1-3.
13-2, my lord. Then, my lord, section 18 says, my lord.
Let him give security.
Exactly. I am coming to your lordship view. Well, unnecessarily delay arguing all these cases. Unnecessarily.
Let him give.
Let him to produce all the original documents before.
Documents I have
That is all. That is all.
Find out
All the original documents before the London court below. The London court is directed to hear afresh by receiving the all original documents.
Original it doesn't have, no.
Original cannot be. These are all.
In which basis they will find
invoices?
Invoices original cannot be given nowadays. It is my lord, through online process the taxes are being paid, my lord. So originals I cannot file.
You had at best had you filed those things before trial court?
No.
Yes,
that is not. Your lordship may kindly say.
Original is not filed. That's what it is. Original is not available. Online copies are available.
So neither signature nor
you
seal,
certify
nothing else.
Write down. The application of the petitioner moved under section 457 CRPC for release of the tobacco articles seized.
Tobacco articles.
Tobacco articles seized from the Bolero pickup van bearing number OD dash
18B
dash 2299 has been rejected by the court below on 9/11/2022.
Yes.
The petitioner took up this matter to the revisional court, and the revisional court, while its order dated 3/5/2023, has also rejected the revision petition, inter alia stating, page 47. Page 47, para, in the present case, to so and so. Mr. Mishra, counsel for the petitioner submits that under section 13.2 of COTP Act, COPT Act, what is the permission required?
Permission for retaining the seized product.
A precondition is mandated under the provision for seeking permission from the district court to retain the seized article
within 90 days. Within
90 days. In the present case, this provision is not complied with. In so far as there is also a violation of section 18(1) of COTP Act. 18(1) of COPT Act mandates,
my lord, that unless a notice is given for confiscation, the materials are to be returned to the owner or the person who is
unless a confiscation notice is issued, the seized product shall be released to the owner of the to the owners. Perusal of the impugn order indicates that the petitioner has failed to produce the original document claiming his ownership insofar as seized products are concerned. Mr. Mishra submits that original copy of the invoices is not possible to obtain in the obtain as he has only got the online invoices, which he has already produced. Without going into the details of the same, I am of the considered view that the petitioner should produce the invoices, online copy of invoice, self-attested copies of online, self-attested copy of invoices, online invoices he has obtained, so as to prove his ownership over the seized product, and the trial court should impose appropriate condition for releasing the product if satisfied on the ownership.
Yes.
If
Yes.
satisfied in the ownership.
Yes.
Subject to the aforesaid observation, the impugn order is set aside and matter is remanded back to the court below to decide the application under 457 CRPC FRES.
Right.
Otherwise also, my lord, under section 18, ଯଦି ସେମାନେ notice ଟା ନଦେଲେ 90 days ଭିତରେ, they are bound to return it.
All
Provision says, my
all the points raised before this court in this present petition is left open to the petitioner to raise before the court below, and court below by taking into consideration the provision of the act and the valuation of the product,
particularly
may impose appropriate condition while releasing the product. Dispose.
urgent copy.
56, may I please, my lords. My lord, this is the case in which I was placing, my lord, my application under 127 3C was rejected, for which I had approached this honorable court in 482. And as per the SR, my lord, there was a noting for change in nomenclature, which was clarified on the last occasion, my lord, for which notice was issued. Notice was issued.
Yes.
What is it? I am on behalf of Mr. Durga Prasad Dhara, my lord. He has been instructed me to he will appear for part number 2. 2 weeks time in criteria allowed for filing of Bharat now because she is staying now at Pune for his treatment.
My lord, may I request one submission, my lord, that my lord, noting as per the SR that may be deleted, my
I
lord.
have ignored that, therefore I wish to notice.
My lord, that is coming on regular, so that may be expunged.
Mr. So-and-so entered appearance on behalf of opposite party number 2 and seeks an adjournment to file the counter affidavit. The time is the prayer is allowed and matter is adjourned to financial check. Mr. Mahapatra submits that there are some noting
As per SR.
cost in the cause list regarding some certain defects. The same may be ignored. Since he has cured the defects and the
My lord, with regard to change in nomenclature, that may be ignored, my lord.
since notice has been issued and the matter is under consideration of this court, the observation made by the SR, which is reflecting the cause list, may be removed.
Highly obliged, my lord.
Right.
57.
Item 57,
My lord, adjourned to 28.
Both parties have come, my lord. Compromise has been held, my lord, and we have filed the joint affidavit.
Yeah, what is the offense?
4080 only, my lord.
So I am for the informant.
Yes. What are the allegations?
Allegation, my lord, I have some money has been mismatched in the account, my lord, and that amount has already been given to the. I am the accountant of the company, my lord.
Joint affidavit.
Filed.
At the instance of the opposite party number 2, FIR number so came to be registered against the petitioner. The charge sheet file.
Charge file, ma'am.
Pursuant to the FIR, charge sheet has been filed in the present case. At this stage, petitioner and opposite party number 2 have settled their dispute and filed a joint affidavit dated 16/2/2024 inter alia stating that the petitioner of depositing the rest of the amount Petitioner has, how much you have deposited?
5 lakh some odd, my lord.
Petitioner has deposited 5,75,386 rupees to the satisfaction of the opposite party number 2.
My lord.
Therefore, the opposite party number 2 doesn't want to proceed with the matter. Proceed with the matter. The petitioner and opposite party number 2 are present in the court. They are represented by the respective counsel and identified by them. They filed the photocopy of their self-attested Aadhaar card, which to establish their identity, which are taken on record. Mr. Rahul, appearing for the state, submits that since the parties have settled this, since the dispute is regarding the transaction of certain monetary dispute is regarding some monetary transaction between the petitioner and opposite party, and the parties have now settled their dispute. There is and filed the joint affidavit before this court. There is no legal impediment in quashing the FIR, taking into consideration so and so. Yes. How much you will pay?
Already paid, my lord.
You paid to him only, no? You have not paid to the
My lord,
welfare of the
500, my lord.
500. You are money to this thing. Give 1,000, huh?
My lord, my lord.
1,000. Subject to 1,000 cost.
Obliged.
What the petition, huh? 58.
May I please, Lordship? Lordship, kindly glance the. The matter here, the cognizance order has been taken under section 73 and 72 C1A of Mines Act now. Here what happened, the brief fact is, in MCL, there is an area, in Orient area, there is a bunker. In mine number 3, an accident happened because of in the fall of the holdings which have been made. There was a loose holding, so that accident happened, and this petitioner, being a staff officer, he has been implicated as due to of the fault of the petitioner, the old repair works have not been done. But the fact is, if my lords will come to page 31, my lord.
Yes.
Page 31, it is an notification of the Mahandi Coalfields Limited dated 13/2/2003. Where may I place that? During the CGMs and GMs coordination.
What do you want to say here?
I hear that the staff of the civil department is not at all coming under that repair work. Civil department is not going to repair the work. The E&M department has the sole responsibility to repair these bunkers, the underground mining things and all.
Let us issue notice. Issue notice.
Here, my lord.
You are appearing for?
Appearing for the, I cannot appear for OP number 2 because he has given the service the copy. So I am appearing. Your lordship may kindly see the cost. Their name.
I will clarify.
It is stated in the name, my lord, Prasanna Kumar Singh. So that should be deleted. Otherwise, I cannot because Paramananda Kumar Singh.
He is the person who has given
maybe this is a criminal case, my lord, and your lordship
prosecution report or complainant. He is the complainant.
Whether
he is the deputy director of mines, mechanical.
Deputy
director of mines.
He is the complainant.
Mining safety and authority. He is the complainant.
And he is appearing for the victim.
Victim is not involved because Union of India, he is alleging against the Union of India Mines Department.
Mines Department.
So Mines Department officer has initiated the complaint petition representing that department.
If my lord, if
he will not there, my lord, if he has been transferred, if he is stated Union of India,
if my lord
will come deputy minor, my lord, I can take notice and I also represent.
Annexure 1.
That I want to.
Annexure 1.
Why is getting into? Why don't you implement?
My annexure 1
is correct here.
I will implement.
Correct now.
Yes, my lord.
Then councillor seeks leave of the court to correct the causality of opposite party number 2, permission granted, he may do so in the court, countersigned by him, and issue notice to so and so issue notice. But you will appear.
I filed an IA.
Two extra copy be sir.
I filed an IA for
I see.
stay of further
First time that to put defect raschi.
for
So I have not.
proceeding of the two
IA
CC
defect
case.
rachi.
My lord,
defect case,
I
yes.
defect. I will have to remove the defect.
Sure, I have to go through the brief matter today itself.
You move application before court.
My lord,
You move application before court below. When petition submit that you would be moving appropriate application before the court below.
for adjourning.
For adjournment,
My
If he does so,
my lord,
same may be considered on.
my lord. Second sub item is also same. My lord.
Both the matters for you. Correction second.
Correction will be
Remove the matter.
more the matters. My lord.
Same order for the April review. Yes.
Obliged.
We'll file counter my lord for which time.
Yes, 60. Item 60.
Please, my lord. But that to quash the NBW, my lord, earlier he was on bail. NBW issued on my lord to 26/9/2023 due to communication gap. He was earlier granted anticipatory bail. Due to communication gap, he could not attend.
500.
My lord, obliged.
Yes.
May I please? May I please, Your Honor? Yes, I am. So here, let the annex order under annexure 2 at page 24, operating person, passed by the learned sessions judge by exercising the revisional jurisdiction in an
By the way, before lunch, before lunch you were here. After lunch you have gone there.
I was here. So
Why should you have that luxury?
difficulties in no luxury. No, I don't take any luxury. I don't seek any luxury. No, the compelling circumstance is there in my house.
Okay.
My mother is on bed. My
Okay. Sorry. Tell me, what do you want? Annexure 2 is impugnated.
Check is not admitted. Is not disputed. Signature is not disputed. Amount is also not disputed. Throughout the trial, throughout the proceeding, defense has accused has never disputed the contents of the check. Before starting the defense evidence, section 45 petition was filed seeking the expert opinion. That was rejected by the learned trial court. And the accused challenged in revisional seeking revisional jurisdiction in the learned decision court. The learned revisional court allowed the petition and directed to
You are the
send
informant.
the
You are the
seek the
informant. When check was signed.
I am the informant
Narayan Panda on the
by
front
the
page.
accused. Yes. Operating portion below 24 aspect of running page 24.
I will just simply issue notice. Let us see. Issue notice.
No, notice was issued. Notice it is admitted. Notice was issued. The proceeding was stayed. But now,
yes.
Now in the meanwhile, the evidence has been closed on the argument stage. But in the your lordship see the order dated 7/2/23. 7/2/23. 7/2/23. Last last para 2. Considering the allegation and submission of learned counsel for the petitioner, this court as an interim measure direct that operation of impugned order under annexure 2 passed in criminal division number 31/22 by the learned session judge shall remain stayed till the next date. It is, however, clarified that there is no stay with regard to the proceeding pending before the learned court below, which shall continue, but it shall not be disposed of without the leave of the court. My submission before the
May I suggest one thing?
now the trial has been completed. on the argument stage. Let it be remanded back.
Well, when I have
ସରିଲାଣି
entered,
ଯଦି ଚାହିଁବେ ଏକ୍ସାମିନ କରିବାକୁ ପଠେଇବେ
I have entered
ରହିକିରି ବି କିଛି ଲାଭ ନାହିଁ.
Yes.
my learned friend then conceding that let the
Trial court will look into it. now.
let the check be sent to handwriting expert. Well, taken up, taken up.
ସେଣ୍ଡ କରିବାକୁ ମୁଁ
I
admit
pray,
କରୁନି.
well,
ସେଣ୍ଡ କରିବାକୁ ମୁଁ କହୁନି. ବର୍ତ୍ତମାନ ଯେହେତୁ
I pray it may be taken up day after tomorrow. Man.
No, but he says, what he says is, now the trial has proceeded.
Well,
Evidence has
and that's the flag end of the trial.
in the light of the fresh evidence and all, if it is necessary or not, let the trial court look into it.
Yes. Yes.
For the justice, but taken up tomorrow at least.
Tomorrow it may not.
Day after tomorrow.
It may not be possible. Dates are.
Day after tomorrow, I will take half a minute.
No, what is wrong in it?
But I have appeared, but I have not applied my mind to the facts of the case. But day after tomorrow.
Okay.
Purely interlocutory order. Revisional.
देखिए, nothing to it.
First month.
Yes, ma'am.
First month. He has not applied his mind. And but you think over it.
Well,
he says that the evidence has already been recorded.
With all respect to my senior.
First, huh?
Yes.
Yes.
63.
May I please, madam? It was earlier before the Honorable Court, and my lord has also directed the opposite party to satisfy the Honorable Court regarding my contention. The multiplicity of application is the sole intention of the complainant herein, my lord. Substantiate that, my lord. It was my contention that initially a case, initially FIR, annexation number 3 was filed, wherein some allegation was made regarding damage of the house property, and that was resulted a final report. Thereafter, a protest petition was filed. Madam, may see there is annexation number 4, my lord. The contention, because as my lord knows, the protest petition must contain at least. I'm not saying that it will remain as such is in the affair. But it contains that particular allegation only. But here, in the affair, that is page 15 to 18, my lord. The relevant part is the page, plain paper is 17.
Okay.
I am such and such. such and such. ଜଣାଗୁଛି ମୋ ହନୁମାନ ମନ୍ଦିରର ପଛପଟେ ଏକ ବଡ ଆଜବେଷ୍ଟସ୍ ଘର ଭିତରକୁ ଶିଶୁ ବିଦ୍ୟା ମନ୍ଦିରକୁ ଭଡା ସୂତ୍ରରେ ଦେଇଥିଲି ମାତ୍ର ଗତ 4/11/2020 ମାନେ ରିମେମ୍ବର ଦି ଡେଟ୍ ଓନ୍ଲି 4/11/2020 ଦିନ ସକାଳ 8 ଘଣ୍ଟିକା ସମୟରେ ଦେଖିବାକୁ ପାଇଥିଲି ଆମ ଗ୍ରାମର ହେମନ୍ତ କୁମାର ସାହୁ ପିଟିସନର ପ୍ରକାଶ ସାହୁ ସଚେନ୍ସ ସହାୟତାରେ ମୋର ଘର ଆଜବେଷ୍ଟକୁ ଭାଙ୍ଗି ଦେଇଛନ୍ତି ମୁଁ ତାଙ୍କୁ ଏ ବାବଦରେ ପଚାରୁ ମତେ ସେମାନେ ସ୍ଲାଙ୍ଗ ଲାଙ୍ଗୁଏଜ so this is the allegation is with FIR. So now after the due investigation it was found to be false one constraining the complainant to file this protest petition. It starts from page 24, madam. I got it, madam.
Yes.
The allegation 4/11/2020 at about 8 a.m. the accused Hemant Kumar Sachansas some laborers broken the asbestos roof of the complainant house. Thereafter, the accused persons taken away the asbestos and furniture of the school with a tractor bearing number such and such. That is not in the FIR, but it has been subsequently applied, which was kept inside the complainant house. The valuation of the article will be such and such amount. That when the complainant protests such illegal action, such and such, accused informant rushed towards the complainant and threatened to kill him by raising an iron rod. At the intervention of the witnesses, complainant escaped from assault. The accused persons rowdy and such and such. Thereafter, after the police direct this, then they have said that we have approached the police. Now they have tried to develop the case to attack the offense of 307. So now, rightly, wrongly, now it is under investigation. There the cognizance has been taken, and that is one part, madam. So, my lord, why I am insisting upon the dates 4/11/2020. So, whatever has happened, it has happened beyond that, my lord. I mean to say, before all such things, my lord. Then, my lord, may turn to the next complaint petition that starts from page 29. My lord, I pray my lord to have to glance page 28, clause 3, date, time, and place of occurrence. 27/1/2016. The date of execution
of trust deed, and thereafter the trustee members called upon the meeting of the different such and such on the house of the complainant and on charge on 4/11/2020 at about 8 a.m.
Prior to that date.
Prior to that, and this 4/11/2020 is also the cause of action of that particular previous case, my lord. One FIR, one complaint petition, my lord. And thereafter, my lord, may see. My lord, may skip all these such things, my lord, may come to this.
Who is appearing for the?
Another complaint case is also there. Another complaint case, my lord, may I pray, my lord, to have.
What is this? You attempted several times. Protest petition filed. Why have you? If that is the allegation, you should have put it in the first FIR.
No,
Why
my
you have
lord,
put
this
FIR?
this is not the matter. Matter
Is there any?
kind
Why don't you settle?
सेटल जाइथिले एठिकी सेंटर को जाइथिले सेमान राजी हेले नहीं ପାଇଁ कि मेडिएशन सेंटर को जाइथिले लास्ट ओकेजन काइंडली मोमेंट फ्रेश मेमोरी लास्ट ओकेजन द ऑनरेबल कोर्ट
I have to examine it. Then you may not have a good case.
there this offense is difference in between them. Last occasion honorable court had said the party to added the party to government and copy served it.
Where is which order?
ଆପଣ କହିଥିଲେ ଡେଟ୍ ଚାର୍ଟ ବି କହିଥିଲେ ଦେବା ପାଇଁ କି
Hey, which order this is? It was not sent. Was it sent to mediation anytime?
Perhaps not, my lord. I'm sorry.
Mediation ଯାଇଥିଲି mediation.
Where is that? Which order?
Okay, so who's
Lok Adalat. It was sent to Lok Adalat. It is 14/8/2023. Permanent Lok Adalat. They expect the Odisha High Court permanent.
Lok Adalat is something different.
Lok Adalat में
Mediation about.
Lok Adalat रे कौन? Mediation रे जानते ना?
मेडिसिन को पठाइଥିଲା
ଦେଇଥିଲେ
ହଁ जी
पे ଦେଖନ୍ତୁ ନା?
सर भी ରାଜି ହେଲେନି ସେଟା ଏଇ ପାଇଁ କି ତେଣୁ
Where is that? Mediation କେବେ ପଠାଲା? ଦେଖନ୍ତୁ. Mediation you are getting confused. Lok Adalat ରେ mediation.
ଏଇଟା କହୁଛୁ କି?
ନା ନା ଏଟା ନୁହଁ। मेडिसिन पठाइଥିଲା ଏଇ ପାଇଁ
ଆପଣ ପ୍ରିପେୟାର ହେଇକି ଆସନ୍ତୁ। ଏଣ୍ଟ୍ରି ମୋଡ୍ ଟୁ କଣ୍ଟିନ୍ୟୁ ଏଜେଣ୍ଟ ପ୍ରିପେୟାର ହେଇକି ଆସନ୍ତୁ। ୟେସ୍ ଏଣ୍ଟ୍ରି ମୋଡ୍ ଟୁ କଣ୍ଟିନ୍ୟୁ 63 what is that 63
3 p.m. ଥିଲା ନା?
3 p.m. my lord, noting.
3 p.m. noting.
3 p.m. to take around 3 p.m. That is the noting.
what is this matter?
That my lord, the quashing of a charge sheet submitted a lesser offense. For that is a 1/6 case file. The offense cognizance taken 302.
3 p.m. Okay. 65
Yes.
The case was posted for call for the injury report. So that due to disbursement of their ration card money, the informant not come today. This case may be kindly taken Monday.
Urgent. Yes. 66
Yeah, please, Lordship, kindly adjourn.
entry mode to continue.
Lordship, I need one adjournment in this case.
Urgent.
Interim order to be continued.
Entry mode.
Obliged, Lordship.
67
Well, 66 is our matter.
No, 67.
67. Yes.
66 he has asked for adjournment. You are opposing.
No, my lord, 67.
67. Okay.
67.
I'm wrongly given.
3629.
No, my lord, I have directed to appear both the parties before this honorable court.
Is there there?
Yes, they are present there. My lord, I have also
What is the offense?
394.
394, my lord.
Let's actually omit the.
What is where is this?
Let's say the matter relates like this 394. So far the 394 is concerned, it is.
No, you have settled the dispute.
Yes, yes.
Yes.
Yes, where is the joint affidavit? What is the offense and all? You tell me. There are two matters.
No,
One matter. Two matters, no.
One
Same-
matter.
Same,
This
same
is
accused,
67.
two applications.
Item 67.
67.
Ramchandra Ponda.
No,
Yes.
66. Our matter is
Our
66.
matter is.
What is 66? Yes, ask for adjournment. That's what I'm asking.
No,
Someone by
our
mistake
power is
mentioned.
not there, my lord. How they have mentioned, the wrongly mentioned here. I think
Our
she has mentioned
What
wrongly.
is happening?
But one year.
This is the 66.
She has asked for adjournment in 67. Okay, 67 crore.
67, my lord, see
That's
the
what I'm
GN
wondering them.
Yes, GN Mr. power is there.
Okay, it's all right. Now.
GN Mr. he is associated with GN Mr.
Okay, ठीक. Okay.
Our matter is
We are in
66.
66.
Okay. You tell me. You have settled the dispute.
Yes,
Yes.
my lord.
Hmm.
And also I have one affidavit filed by me, my lord.
Where is that? Where is the informant?
My informant affidavit has already filed.
Ritesh Ranjan
Yes, Ritesh Ranjan.
Patua.
Yes.
Fatwa. What is the?
Just Mr. Maharaj.
My lord.
Just see, ask.
Yes, please.
Ritesh from this side. And who is Subrat Kumar Mudali?
Yes, Subrat.
Yes.
Subrat Mudali and Rakesh Swain.
What's it?
ଆଙ୍କର କିଛି କେସ୍ ନାହିଁ ତାଙ୍କ ନାଁରେ କେସ୍ ଅଛି
Or forgive account. Right. At the instance of opposite party number 2, FIR number so and so count again. This so and so came to the state. Investigation is on.
Yes.
Charge sheet filed. No. Charge sheet filed.
That's it.
Charge sheet has been filed.
Yes.
As per the instructions.
Charge sheet filed on 7/9/2023.
Charge sheet has been filed by the police on.
PS case number के
कर दीजिए उनको।
Yes, PS case number कितने को?
PS case number
Yes, case number
122.
yes.
Yes,
Abhay Chandrapur 122.
122.
Charge sheet filed
Charge sheet filed on
7/9/2023.
7/9/2023 under section 394.
Yes, my lord.
Charge sheet.
But 294, 323, 324, 506, 34 IPC and 341 of IPC.
Again, petition. Petitioners have now settled the petitioners and opposite party number 2 are present in the Mr. Maharaja appears for the state and submits that test since the parties have settled the number 2 and filed joint affidavit dated opposite party number 2 has filed affidavit. Opposite party number 2 has filed an affidavit dated 22/2/2024 in Rilia, stating that he has on the intervention of the local gentry, village three, and well-wisher, he has entered into the settlement with the petitioner and settlement with the petitioner.
Subrat Kumar Mudali.
Petitioner.
Rakesh Swain.
Maharaja appeals for the state, he submits that the party that certainly will be put and file the joint affidavit to that effect. Affidavit to that joint affidavit to that effect. Affidavit that there is no legal impediment in working with party. You keep 500 each or 1,000?
ଦି ଜଣ ଅଛନ୍ତି 1000 ଟଙ୍କା ଲେଖା ଦିଅନ୍ତୁ ଗୋଟେ ଯାଉଛି ତ
1,000 each. Or
welfare fund
1,000.
500 each, your lordship.
1,000 you give, you have antecedent also. That's the problem. Otherwise, it's difficult to quash because of your incident.
Obliged.
Now, how many
Three.
cases are there?
Three.
Three cases.
All right, 1,000 each.
Court should not indulge in these kind of cases. Because you have NDC wrong. See, you have been attacking people like this.
Anticipated for
Rewrite for it now.
NDPS are anticipated.
NDPS also.
दियो then.
1,000 each.
ಎಲ್ಲ ತಗೋದ್ರನ್ನ ದಿವಸ
Yes. 63. Night. 63.
63.
Okay. Next. 63. Let us exhaust the board first. There are many people are waiting. Let us exhaust the board. There are very less matters are there. Exhaust the board. Because once it goes on, I don't know how many.
ଏବେ ସରିଯିବ ତାପରେ ଚାଲିବ ଏବେ
Exhaust
ସରି
କରିଦବ।
ଏଇଟା ଟିକେ ଏକ୍ସଜଷ୍ଟ କରିଦିଅନ୍ତୁ
Board exhaust.
Yes, yes,
Okay.
yes.
68. 68.
May I please, my lord?
Total कितना? 75. हाँ, ठीक है.
My lord,
Yes.
this is an application for quashing of the cognizance order, my lord. My lord, matrimonial dispute. On the last occasion, my lord directed to
Offense?
Offense ହେଲା
376.
1376 ଥିଲା ଗୋଟେ ଥିଲା ସେ ସେଠି
ଆଉ ଗୋଟେ case
ଟୁଲା ସେଠି ଆସିନଥିଲା ବୋଲି ସେ କହିଥିଲେ ଆସୁ ହେଲେ ତୁ
Where are they?
they are standing there.
No, first you talk about this case. This is first case is 69 na?
297.
4882.
4882
4882. The offenses are 341, 294,
Only 506.
323, 506, and 34. Here the parties have settled.
My lord.
Write down.
Food party number.
At the instance of opposite party number FIR number so came to raise it. The who is the opposite party number 2? Manju is there. And Chaitanya.
Chaitanya.
Manju and Chaitanya.
Chaitanya क्या है तेरे चैतन्य
Have you filed the affidavit?
My lord.
The opposite party number 2 wide affidavit
yes.
dated 1/11/2023. 1/11/2023 has stated that on the intervention of the village gentry and well wishers, she has settled the dispute with the petitioner and she doesn't want to proceed against the petitioner anymore. The opposite party number 2 and the petitioner are present in the court. The same partner present in the court, represented by advocate, and they are being identified present. And they filed photocopy of the so. Okay, same paragraph. Mr. Maharaj appears for the state and submits that since the parties have settled their dispute and filed a joint affidavit. Joint affidavit is matter. There is no legal impediment giving indulgence in this matter. So accordingly, in the aforementioned sections have been filed, it's called yes. Pass. This is done. Pass. Next.
Yes.
What about the next one?
Next one वाले case का 297 my lord.
318 of 24.
My lord. That the informant is Tulsi Behra.
Very true, Sivera. What is the FIR number?
It does.
Yes.
Tulsi Behra.
76 is there.
My lord.
What is the terms of settlement?
My lord.
What is the terms of settlement?
Settlement, my lord, that is after this dispute within the family, my lord, land dispute. Now matters have settled, my lord. They are residing, both are residing happily.
Married or what?
No, married, my lord, not made the mistake of fact, my lord. Not 76 made out actually.
376 mistaken of fact. Okay, at the instance of Tulsi Behra, the FIR so came to resident petitioner. So, the petitioner and opposite party number 2 are resident of village Bandar, BNGS Bandar, PS Jamakhandi, Jamakhandi, Ganjam. Where is the affidavit? Ganjam. Ganjam. The opposite party number 2 has filed an affidavit dated 19/1/2024, inter alia stating that on the intervention of the village entry from the well-wisher must be settled within 2 to 3 petitioners. She had filed the FIR on the due to the misunderstanding, and now she has settled the dispute. Petitioners and opposite party number 2 are present in the court. They are represented by their respective counsel. Being identified by them, they filed a photocopy of Mr. Maharaj appears for the state and submits that since the petition, since the opposite party number 2 has now filed an affidavit, inter alia stating that due to misunderstanding, she had filed the case against the petitioners. And
there is case and counter case between the parties.
And there are counter case. There is a counter case also filed by the accused against the opposite party. A petitioner against the opposite party number 2, and all of them belongs to the same village. And on the intervention of the village gentry, we said they have settled their dispute. There is no legal impediment in quashing the FIR, taking into consideration from us.
Okay, what a minute. Hello, Mukul. Tuna Seti, Monju Seti, Tuna Seti, Monju Seti, Tulasi Bera, Tulasi.
चलो जी बताओ dispute continue करो how many
Item 70. Item 70. I just pray for 8 weeks time. I was requesting my friend, let there be a settlement in the district level because both of them are working. If your lordship direct the district mediation center, there can be possible one sitting at least.
Because actually my friend is suggesting for this High Court Mediation Center, but now my client is having
His client is
she is somehow some problem is there to come to Cuttack.
On 1/2/2024, notice was issued to opposite party number 2.
She has come.
Also entered appearance of 5 the councils appearing for both the parties conjointly submits that the matter could be settled.
No, Lordship, that is not with me. My client is there.
It is from my side.
It is his submission.
It is from my side.
He says that I will try for settlement. So we cannot dispute that stage. My client is there. She said.
She doesn't.
No, she doesn't.
No, she doesn't want for Cuttack mediation.
Not exactly. She is also.
She can join there. What she said.
The petitioner submits. The petitioner submits that there is a possibility of settlement in this matter, and it can be referred to mediation. Mediation.
Since she has difficulty to attend Cuttack.
Opposite party number 2 appears, and on instruction from his client who is in the court, submits that although he is not, although she is not hopeful, but hopeful in the settlement, but she can give a try. She can give a try. Keeping in view the aforementioned submissions, the matter is relegated to the mediation cell, district mediation cell.
Jagatsinghpur
district mediation cell to explore the possibility of settlement between the parties. Let the party appear before the mediation cell on 5th of March 2024. Awaiting the mediation report adjournment.
Lordship, fix any date after 8 weeks after.
8 weeks.
Great.
71. 71, Lordship. The report of the mediation must be there.
Yes.
So
done.
No, Lordship. In fact, it deferred to First March, Lordship. Because
Then-
she came from China border,
Okay, then
Lordship.
give it. The mediation in this case is still on.
Lordship.
Now the next date before mediation sale is fixed on 1st of February. Urgent the matter. Awaiting.
1st of March.
1st of March. Awaiting the mediation report. Urgent.
Lordship. Entry mode to continue.
Entry mode to continue.
Lordship, great.
Yes.
72. Separate Lordship.
Yes.
72, my lord. Last occasion, my lord. So ISO.
Hi. Got a minute.
Yes. The Daswantpur
Yes.
police station.
Yes. But they are on online. Ticket and coil.
Oh, that for that disbursement.
Yes, amount disbursement.
Amount.
Yes.
Letter was sent in.
Yes, they have gone.
Yes, yes.
They joined already.
Yes.
And you will also may kindly take the instruction. Yes, she has given. My lord.
What she said?
She has already disbursed the amount.
Disbursed?
Yes. As she has stated.
To all the members of the village committee.
Yes. Madam.
Now you can quash.
Yes, very well. See, जो complaint होता है मुझे एक कैसे सपने से क्या तो.
Okay, thank you, madam, for the efforts. Thank you very much for the efforts you made. Now I'll take this instruction on record and quash it. Okay.
Sir.
Right now.
Yes, sir.
Thank you.
Thank you. अपन leave करो तो. ये decision टा नहीं. File. Decision टा file.
The matter was taken up for hearing on 16/2/2024 and this court has passed the following order. 16/2/2. Okay. Thereafter again the matter was listed on 22/2/2024 and the IIC Daswantpur police station district Koraput was directed to appear before the court. Appear before this court. He has appeared today in the court through video conferencing. Full stop. The IO of the case has also, the IIC Daswantpur has also given a written instruction to the Land Council for the state, Mr. Maharaj.
Yes.
Maharaj. The written instruction is taken under court. Full stop. As per the written instruction, the disputed amount has been disbursed to all the members of the village committee, to whom the money belongs, including the complaint, including the complaint. In view of the aforementioned, instruction, Mr. Maharaja submits that there is no legal impediment in quashing the FIR.
Yes.
Taking into consideration the aforementioned facts and circumstances, the FIR is quashed.
Yes.
And consequently, take it out.
74.
74.
I am permitted to forward movement.
Yes.
My lords, there is a conviction against revision against conviction. It is supposed to come up for hearing. Now, I don't mind arguing the case. At the present, status is not known. If the state council be asked to, through the police, or the whereabouts of the accused persons.
Okay. The revision is against the conviction order passed by the JMFC, na?
Yes, lords. JMFC Jaipur.
JMFC Jaipur in GR case number 78 of 2022 passed on
2002.
18/11/2010. 18 counsel for the Mr. Samantha and counsel for the petition submits that he doesn't know the present status of the petition petitioner. Let the Mr. Rahul Levini for the state states let the state council seek information. Which IIC?
It should be
Jaipur.
Which is that police station? Jaipur police station.
MB 86, my lords. They are residents of MB 86. Malkangiri PS.
86
Malkangiri PS.
MB 86, there is a police station named MB 86.
No, it comes under Malkangiri PS.
Acha. The IIC of Malkangiri PS is directed to verify the status of the petitioners. Those who have given their address as those who are belongs to MB 86. MB
86. Same village, all of them.
Please the matter for the
2 weeks or 3 weeks after you also may fix the date.
Sorry? Pre-copy.
Last may fix it 2 weeks or 2
You have the memo of parties? You have the memo of parties? Do you have the memo of parties? The accused names?
Yes, my lord.
Memo of parties. You have not?
Yes, that is there.
Five.
Yes, that is yes,
And you send these names to the PS Malkangiri and
yes, one free copy also can.
Free copy.
My lord, recorded I am Devashish Sarangi, my lords. My lord
Sorry.
says some.
Oh, Devashish Sarangi.
75.
I'm sorry, Mr. Sarangi.
75.
I'm still, yes.
75 I paid time because I am not present the file. 1 week after I'll take also.
75 times. But he is there.
Again.
He will give you the copy.
Yes.
Take the reconstruct it. Okay. When do you want?
1 week after.
It is very old matter. We can finish.
Yes, 1 week after.
2 weeks after.
2 weeks. They can review. That's how the revisions are not being heard. That's the whole difficulty. Either we don't know the charters or something happens,
No, it's like Mr. Sarangi.
Sarangi.
He makes a statement because his clients are not in his.
Actually, my lords, at the time of giving the brief, and
No,
the
Mr. Panda is taking the liberty thinking that you are on mute. So I will not reply.
No, I am not replying. I explain it further. Because the
Even does your lordship need his explanation?
the feeding lawyers, they change with time. Now, more than a decade. Now, they also has no contact. That makes all the difference.
They have also gone to meet their makers.
Okay. No, 63.
May I please, Your Lordship?
Yes.
Before commencing my submission, I would like to say that the Code of Criminal Procedure is a complete procedural law so far the administration of criminal justice. And the legislature, while drafting a code, they have kept in mind all the aspects which may arise and which may cause any hindrance in the administration of either the victim side or the accused side. So, in these premises, now I will straight come to the factual aspect of the case, which is more important. My lord, this case was instituted by the father of the deceased by way of filing a protest petition. Your lordship have a glance through Annex 3, page 18.
Okay. Yes.
And in that case, the caption which has been quoted in the petition is a protest petition arising out of Paralaxamul PS case number 141 of 2021, corresponding to GR case number 334 of 21. That means a affair was lost, it was investigated, and subsequently final form was submitted, and the complainant, who was the informant, he agreed with the
way of investigation and file the protest. When the protest petition can be filed, if final report is being submitted or final form is submitted omitting the graver offense which was earlier registered, or in case the persons who are named, some names were omitted. In that case, a person is aggrieved and he is to seek the recourse of the court. Now, in this case, I would like to say, your Lordship may kindly have the page 20. Page 20, clause 1. It relates to the what are the contents in the FIR itself.
Yes.
Thereafter, if your Lordship will go to the entire narration, it relates that the investigation which was then carried on, that was not properly carried on. It is a perfunctory investigation as it has been stated. That's why in page 23, the grounds were given where there is latches in the investigation. Am I clear, my lord?
Page 23.
I am.
Yes.
Your Lordship may now turn to the last page. That is prayer question. Now I am placing the prayer question, what it says. Therefore, the complainant prays that your honor may graciously be pleased to consider the facts stated in the complaint petition and may kindly direct for further investigation into the above pointed out lacuna. I am giving emphasis. Under section 1738 of the CRPC by a court appointed SIT to ensure the justice is sought. So the limited prayer in the protest
173.
subsection 8 of the
Right.
thereafter, I don't know what prompted the Lord Magistrate. He did not accept the prayer of the complainant who is the aggrieved party there. But straightway he proceeded it in form of section 200 of the CRPC. Am I clear, my lord?
Yes.
Now, what are the order passed in pursuant to preferring this complaint petition and prayer made by the complainant? I am not possessing that first order. If Mr. Parthanak is having that order.
No, I have not possessing the order. But
Oh.
the petitioner has filed.
What was the first order?
Yes, exactly on receipt of the complaint with a prayer of such. What are the order
I
passed by
have not
them?
obtained. The magistrate straightway recorded the statement of the complainant, initial statement, and conducted inquiry and took
No,
cognizance.
the prayer was 173.
My lord, even if the prayer is 1738, but magistrate can, I will cite the case law on that.
So what are the order passed? Why the magistrate did not accept the prayer and instead of that he thought that 200 is to
No,
follow.
I have not.
That is the crux of the matter.
But
Where
magistrate,
do you have? You don't.
No, no, my
but
lord.
magistrate can proceed with.
No, can let us see the fact first.
My lord.
Let us see, understand the facts. It can or cannot. That we will see.
That is a different.
But if
But
if
I have
he has
not-
given some reasoning, if that reasoning is wrong
exactly,
or right,
exactly.
whatever, that thing you have to see. After giving reasoning, whether he has produced, proceed further, or without giving reasoning, straight away 200.
That's why he treated it as a complaint petition
Complaint
and
petition.
proceeded under section 200.
Do you have anything?
No, I have not.
Get it.
Petitioner will get it.
I am requesting one thing, my lord. Nowadays, we can call for the report which can be sent by scanning all the order sheets.
Scanning, you call for the scanning report. Proceeding.
Photostat
Proceeding.
copy of the entire record, criminal case, one case as well as JR case. It will be better for better adjudication. Everything can
Yes,
be.
yes, call for the scanned copy of the proceeding in GR. In,
Complaint case as well as GR case.
case.
Yes. Okay. And fix a date for the entry mode to continue.
And date and time, my lord.
Time, end of the board I'll take so that
3 p.m. will be, my lord. Today it is fixed as 3 p.m.
3 p.m. whenever you are feeling, fix 3 p.m. so that we can hear it. You can start. Because there is-
Tentatively 3 p.m. after the completion of the board,
Yes.
that's the matter
It's the
kind.
last item.
Instead of
Last-
detaining others.
Yes, it's last item. It's last
Ala.
item. Okay.
3
Last.
p.m. we will wait, my lord.
Yes, yes, last item.
Get the
They will. देखिए सेट कर दबो जो हियरिंग
Interim order to
interim order to continue.
Sir.